Good morning. Good morning. It's Wednesday. It's March 26th, and today I am on the road. As you can tell, I tried to move my suitcase out of the way. Clearly, it's not. Everything is fine. Streaming is dynamic, but I am on the road today and was flying yesterday and had no Wi-Fi. So today we are going to cover the Karen Read hearing that happened yesterday. If you have already seen the hearing, thank you so much for no spoilers in the chat. We are going to go through everything that happened in the hearing yesterday, and the judge issued orders yesterday afternoon after court, and we're going to go through those too. Many of you have already seen that the motion to dismiss was denied. Most of you are not surprised by that denial. I think all of us are frustrated that there wasn't an evidentiary hearing. When we cover that ruling, I will talk about it, but the court did issue the order on that motion to dismiss. We'll go through it quickly. We'll do a deep dive probably on the Emily Show podcast that drops every Monday, because today I don't think we're going to have time to deep dive it. I am definitely trying to make sure that we can cover live court as we get ready for jury selection. What does that mean for the Karen Read trial? It means that jury selection is starting on April 1st. They probably won't start evidence until the end of the day. Or no, the end of the month of April. They're definitely not starting evidence the end of the day of April. The court is very worried, and I actually understand her concern here and agree with her, is very worried about picking a jury in this high-profile case, and with the amount of media attention and the fact that this is a retrial. So people who might not have seen this in advance of the last trial might now be looking at this case going, oh boy, I wasn't going to be on a jury. I'm local. I watched the first trial thinking there's going to be a resolution, because most think that there's going to be a resolution. It is less common to have a hung jury, and then you get to the end of the trial and people locally might have been watching, and now you've got to find a jury for a retrial. And that is going to be difficult. And the judge is correct. That's going to be difficult. They are going to need to bring in hundreds of jurors to balance this out. So with all of that, we are going to go to live court. We are going to chat about the things. So Eileen asked in the chat a great question. Is an evidentiary hearing still possible when introducing new evidence? Not on the motion to dismiss. That door has closed. But is an evidentiary hearing still possible for matters regarding experts, the ARCA experts, and those sorts of things? Yes. Yes, it is. I think that the court has set this up as an issue. I can't believe that there wasn't an evidentiary hearing, but we're going to go to live court first, and I'll give you more of my thoughts on that later. I think with the amount of issues with the videos, you need to have a hearing, but you know my thoughts on it. I'm not the judge. I don't practice in Massachusetts. I'm a lawyer with a microphone that has opinions and shares them with you. That's what I would have wanted to see. That's 100% what I wanted to see. And the court thinks it's not needed, but there's a lot of sussery around those videos. That doesn't mean, though, that there won't be hearings before those videos are admitted, but that's frustrating to the defense. I don't think they should wait till they're in trial to have those hearings to figure out where the videos came from. That's incredibly frustrating, and it's just not the way that this should go. But Emily, would we even be covering the case if this isn't the way things should go, wasn't the thing? So I saw some of you in the chat saying that I'm quiet. I'm hoping that I'm leveled with court, but again, travel setup is what it is, but I don't want to overclock the court. So we are going to go to live court. Lawnards, it's good to see you. We have so much to cover. Thank you for your patience with streaming setup. It's always dynamic. And when you set things up the night before and everything works great, and then you are there in the morning and nothing's working the way you anticipate, it's just huzzah. I have a coffee. Look, the lovely folks at Starbucks were glorious, and I think I've walked about 17 miles because New York, and it's like, oh, it's just you know, it's silly to hop in an Uber. It's not that far. And then throughout the day of it's not that far, it ends up, you know, a little by little, it ends up being a lot. I am too much of a Los Angeles snowflake to handle New York. Y'all New Yorkers, I know why y'all are built different. I know. I know. I know why y'all are built different. It is needed. Look, man, if I can't drive my car to Trader Joe's and put all the groceries in the back, I don't know how to exist. But I always enjoy New York City. This is my favorite type of weather. So it is lovely to get out and walk around a little bit. Though also I am a baby with like my eyes watering like down my face. Like I literally cannot. I am such I am look, man, LA's got sunshine. Look, you get pounded in the surf growing up learning to surf, but New York builds y'all different. And I mad respect, but I enjoy it. I'm here for a YouTube event. I'll tell you more about it after the YouTube event, but I'm here for a YouTube event. So let's roll the intro. Let's get into it. That is why the travel set up. But I enjoy visiting New York. It makes me motion sick as all hell getting into here with the winds coming across different directions and the traffic. But once I'm where I need to be and I can walk to everything out, uh, when I can walk around to everything I need, delightful. Also, you guys have a Starbucks roastery. Ah, amazing, amazing. Squeaky Ghost. I love Alaska, though I've only been in like May. So, again, that's all different. I went to law school with a few folks, my first year of law school before I transferred, with a few folks from Alaska. Again, a whole different vibe. Law nerds, I need to still roll the intro. I keep saying I'm going to, and then I keep chattering. There will be plenty of time for chat. My goal is to get through the hearing and then chat. If everybody is speaking at a relatively considered pace, I might put us at 1.25. I'll let you know. It's harder to gauge the demeanor of the lawyers at 1.25, but I think we've just gone to full tilt snark with all of them. So I don't know if that really matters all that much because we're just at like DEFCON snark. So let's roll the intro. Let's get going. Time to go to court.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
Welcome, welcome. We're going to court. I don't even know if we can hear the hear ye's, so I'm gonna do it. Y'all let me know. Y'all let me know what is needed volume wise, because I can't tell from my in-ears. I'm trying to balance me and y'all. B2 is just making it rain. B2, thank you for all the gifted memberships. It is incredibly generous. RIP to slow mode with our incredibly generous gifters. Thank you, B2. And remember, the mods put a little directive in the chat. If you are interested in getting a gifted membership, that's all handled by YouTube, but you have to turn it on in your account. So the mods will put a little link in there so you can do it. But B2, thank you for all the gifted memberships. Welcome new members. Enjoy the no slow mode life. It is just the best. All right, let's go to court. Hear ye, hear ye. Court is law nerd court of the internet is now in session. Draw near and ye shall hear Emily talking over the attorneys when they annoy her. The fact that I was able to get the right button on the mobile soundboard is a 10 out of 10. Today's going to be a good day, y'all. Today's going to... Oh, don't jinx it, Emily. Today's going to be a good day. Let's go to court. Hopefully we can hear court. That sounds a little low to me, but you guys let me know. I can turn it up.
Good morning, Your Honor. Hank Brennan for the Cotton Bar.
Ooh, I need to move those immediately.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed. Ms. Little.
Morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
The chat always says, good morning, Miss Little, with a smile. What in the heck? No! I was just trying to pause. Goodness. I should have knocked on wood harder. I really should have. The court always says, "Good morning, Miss Little," with a smile. You guys are saying the audio is low, like low. So we're gonna do our best. We're gonna grab some apple bottom jeans and boots with the fur and turn it up a bit. So let us back up. Take two. Emily, never say anything. Just never. Just never. There we go. How are we feeling?
Good morning, Your Honor. Hank Brennan for the Cotton Bar.
I hope we're not blasting it into your ear holes.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Morning,
Did
Your
you
Honor.
hear it?
Robert Alessi
Good
on
morning, Miss
behalf of
Little.
Ms. Reed.
Court loves Miss Little. You guys, I love that you're still singing.
All right, so before we begin, Mr. Jackson, when we left the other day when we were talking about Michael
I
Easter.
can gain this up a little bit. Let's see.
I gave you the opportunity to get some authority on expert testimony and board of defense. Were you able to do that?
We were.
Do you have some?
The court is asking the defense to start with expert witnesses regarding the Bowden defense. This is the law enforcement. WTF, you should have investigated, not just investigated the case better or differently, you should have also investigated other individuals and what options there are or were. So it's a type of a third-party culprit defense, and it's more in the neighborhood of not some other dude did it, which is your typical third-party culprit, right? Some other dude did it. There's a variation of that that's just like full shaggy defense, it wasn't me. And then there's like some other dude did it, and that's the dude we think that it was. There's also the co-defendant, some other dude did it, where they just point at one another. And then there is the Bowden defense, which is a spin on that is law enforcement should have investigated these individuals that had the opportunity, et cetera, to commit this crime. So the defense wants to bring in an expert in policing and police procedures so that they can talk about, a normal investigation looks like this. If they get a lead, they would ask those people, I don't know, questions. Individually, they would maybe be like, oh, you destroyed your phone and your SIM card? That's weird. Maybe a detective would take a look at all of the butt dials and go, strange, and then investigate that further. So they want to bring in an expert to give comment on that or expert opinion on that, because what law enforcement should or shouldn't do or would or wouldn't do is different and is specialized knowledge. We can all speculate, but bringing in an expert saying police would do this and that is proper, in my view, is proper purview for an expert. I said it last stream, I'm going to say it again. You can be an expert on just about anything if it is something outside the general knowledge of the jury. That's the point of an expert. So depending on what the topic is, you can have experts on all kinds of stuff because they have specialized knowledge that the jury doesn't. You just have to show that they are, experty. All right, let us continue on. And for those of you just coming in, we are covering yesterday's hearing because I was on a plane with no Wi-Fi. They're taking this whole Gen Z, and again, Gen Z, no hate, just the fact that my children now say raw dogging about stuff is weird to me. But Delta is like, oh, Gen Z, we've got you. No Wi-Fi on the flight. Y'all are going to raw dog the flight. I'm like, I grew up in a different time. Why is this the word? I hate it so much. But either way, we are, I'm just like, going on a flight without Wi-Fi is not what is meant. Stop it. Just stop it. But that's what we did on yesterday's flight, which was absolutely fine. Nothing makes me feel more old than being like, these kids today. And this is the thing that I'm number one, like, these kids today. So, All right, Chad, I will let you guys discuss the veritable new uses of the term raw dog because we all grew up in an era where just like going without Wi-Fi on a flight or going without entertainment is not what was meant. Is not what was meant.
Yes, it was filed yesterday. I do have a courtesy copy for the court.
Okay.
And this is why the court loves Miss Little. Yes, we filed it yesterday, but I have a courtesy copy for the court. The court loves it.
That's,
Gonna suffice.
I think so. I'll take a look at it.
It's got everything in it that I would say orally anyway, but if the court has any questions, I'm happy to answer any questions.
All right.
Yeah, I see all of you saying the audio was not great yesterday either.
Thank
I
you.
get it. I've tried to turn it up as much as I can without distorting it because that's even worse. But
Similarly,
we are in the mercy of court.
regarding the third-party culprit argument the other day, Mr. Yannetti, I see you did file something late yesterday, so I got that. I'm just wondering if either the Commonwealth or the defendant want to be heard on that.
I bet they do. I bet they do.
The Commonwealth does.
All right, I'm gonna move my.
I'll hear you, Mr.
I'm gonna move these two things that are annoying me because they are annoying me.
Your Honor asked for a proffer from the defense regarding third-party culprit.
Yes.
Alternatively, evidence that would be separate regarding third-party culprit aspect of Bowden. Would be
Do we just put him on 1.25 now? And y'all, I tried to gain up. Let me try to gain up this audio a little bit more, and then I'll put him on 1.25.
received some information from the defense that does not distinguish
He's clear
whether
enough.
their intention is that it applies to third-party culprit or whether it applies to a third-party culprit aspect of Bowden. Those concepts are logically and legally distinct. Regardless, when you look at the proffer by the defense, it is insufficient.
Who said put him on
for both
5.25?
Third-party culprit and for any third-party culprit aspect of Bowden. Two different analyses, but the evidence is equally feeble for both. Relative to third-party culprit evidence, there are a number of cases that I know Your Honor is aware of that guide the standard of third-party culprit evidence. Not to iterate the law because it is clear, but there must be relevance, there must be a substantial nexus between the claims of the defense and the third-party culprit theory. They
Right.
provided us 3 people that they identify as third-party culprits. It's helpful just for a quick synopsis of the history.
Oh boy.
In this case, prior to the first trial,
Quick
the defense
synopsis,
never
huh?
identified a third-party culprit.
We're going to put him on
At some point,
1.25.
the defendant herself said that they knew who the third-party culprit was, and recently, the position of the defense has shifted that they don't know and don't need to know. Now, the law accommodates specifically identifying somebody. It also accommodates general, but it has to have specificity.
Y'all,
It has to be a motive, an
The
opportunity,
volume
and an
just
intention.
completely went wild, and then my extension also was just like I can't even pull it. The sound from court yesterday was an issue. We're going to do our absolute best. Let's see what we can do with this real quick.
And there has to
So,
be evidence that
bear with
draws
me.
correlation. It can't be bad character, speculative, or just putting out
There we go.
information that's negative towards a witness so that that can backdoor prior bad acts against a witness and be used for a different purpose.
I'm trying not to
They identified
kill
one
y'all's
person,
ears.
Colin Albert. And in their proffer, what they offer, number
So
one,
hopefully that
it's
works.
important to take them separately because it shows how feeble it actually is. The first thing they say about Colin Albert is he had a feud with John O'Keefe in the weeks and months leading up
All right.
to January 29th.
Let's put him on 1.25 now.
Now, other than maybe on social media or in interviews with the defendant and national broadcast, there's no evidence of that. There's no evidence that's going to be admitted at this trial. that
Oh,
shows
that's
a
better.
feud between
That's
Colin
so
Albert
much better.
and John O'Keefe. There is no evidence that there was any hostility between Colin Albert and John O'Keefe. There's no evidence of a motive to kill John O'Keefe by Colin Albert. There is no evidence of any motive, of any intention, or of any opportunity whatsoever. In fact, the evidence is that Colin Albert was not even at 34 Fairview at the time John O'Keefe arrived there on January 29, 2022. And so simply saying it is not evidence. And an attorney should not be allowed to confront a witness about an allegation that has no factual basis for them to then have to defend the accusation. The prejudice then seeps to the jury, and the Commonwealth is in the position of having to disprove a claim that had no basis to begin with.
Well, that's why there's
Second claim that
rules
they made
of
regarding
evidence.
Colin Albert is that he had
There's
thrown beer
rules.
cans in Mr. O'Keefe's bushes and told Mr. O'Keefe to F off in his face. There is no basis for those claims. There is no witness for those claims. There's no information regarding those claims. I understand there may have been a party where there was beer cans, but there was no Colin Albert. So to attribute a situation or an incident to him, the defense would need some good faith proof, actual proof, fact, that this actually happened. And there's no evidence whatsoever that Colin Albert threw beer cans in Mr. O'Keefe's bushes and told him to F off. And the reason there's no proof is because it didn't happen. So again, the defense asks for an invitation to simply cross-examine a witness, allege a prior bad act, and then the witness has to defend their honor and the government has to disprove it. That is not the cloth that third-party culprit is made from. Regarding the suggestion that there was some type of...
Did that work? Did that work? All right. I reselected, so we have much better sound. Good. We didn't miss anything. Let me summarize, Brennan. Your Honor, they can't just say shit. They can't just say shit. Okay. Perfect. Perfect. Sometimes you gotta just shift the settings a little bit and the tech will decide it wants to work. So we will make sure that it's not too loud, which I don't think is the worry with court. So, all right, good. Brennan said the defense can't just say shit. They have to come in with relevant fact-based evidence before they can bring up some of the defenses. With the Bowden defense, though, I think the defense can say, should the police have investigated this? Should the police investigate that? Kelsey in the chat said, no, it's bad. We can hear Brennan now. There are some legal arguments in here that are needed because there is nuance in this argument. And the court had a nuanced ruling in this last time where you can't just say shit until there's evidence to support it. Everything needs evidentiary support, but in the type of argument the defense seems to be making is not, we're saying 100% this person did the thing. What the defense is trying to get to is, we're saying the police should have investigated this person or these people because they are connected in some way. So there's a nuance in that argument, and you have to show the connection before you can start arguing that the police should have investigated it. I think with all the butt dials and the rehomed phones and all the other behavior and the location and proximity, I think there's reasonable foundation to say you should have investigated these people, at least interview them separately to start, right? Interview them separately before you go from there. So not the argument that I know 100% this person did the thing, not Karen Reed. Instead, law enforcement should have investigated these avenues, and they didn't because of Proctor. I think it's a better argument than the first trial. I think it's an argument that's easier for a jury. I think it's an argument that doesn't require a jury to say, oh, did the defense prove that Jen McCabe is lying, or did the defense prove this or that? I think it's a better argument to say, look at what Proctor said about Karen Reed. Look at him getting terminated, and then look at all these other people that weren't interviewed. Why didn't they interview them? Why didn't they try to find out what happened to John O'Keefe? Well, because they decided Karen Reed did it. And so that's all they're presenting you. But they didn't do a full investigation, and the evidence here doesn't show that. I think it is a better argument. It doesn't require the jury to make as many steps to get to everyone's involved in covering something up. It focuses on what law enforcement did or didn't do, and it allows them to focus on Proctor and Proctor's firing to say they were investigating the case to come to the only outcome possible that Karen Reed did it. They weren't investigating the case to find out what happened to John O'Keefe. So again, I think that's a stronger argument for the defense because it's simpler, right? Carly in the chat said, yes, but Karen Reed was framed. Sounds so cool in an opening statement. I agree, but I think that the dynamicism, is that a word? Whatever. Travel day, brain foggy, coffee not done. I think the defense team is dynamic enough to say law enforcement decided that Karen Reed did this from the moment they started the investigation because of a biased lead investigator who has since been fired. And the evidence will show that the evidence never pointed to Karen Reed. The evidence never pointed to Karen Reed, and law enforcement never followed the evidence. They followed their predetermined outcome, and they refused to look at any other option. And then you can get into the blue wall, and then you can get into all of the rest of the arguments that they were never going to investigate one of their own. They were never going to question a Boston cop who had a dead body on his lawn. Never. They were never going to question other residents of Canton that were their friends, that were their drinking buddies. They were never going to question them. They were always going to blame Karen Reed no matter what the evidence showed. It's a lot less of a leap. And so I'm interested to see how the defense simplifies the trial, because if the defense simplifies the trial, it makes the Commonwealth's case confusing. Because if the Commonwealth is the party that has to make the leaps, then there's doubt. If the Commonwealth is the one saying, well, you have to believe this and this and this, that leads to doubt in my mind. The Commonwealth needs to be able to come in and say, we know that Karen Reed is responsible for the death of John O'Keefe because A, B, C, D. And that it has to be that simple. If the Commonwealth can't make an opening statement that's that simple, it's because they don't know their case. They never should have charged count 1 and 2, count 1 and 3. This always should be a count 2. She drank, she drove, she dropped off John O'Keefe. She did not assure that he was where he needed to be, and that's the end. They should have stuck with those 3 things. I haven't spoken to anyone, any lawyer that I know, either defense attorneys, retired attorneys, judges. I talked to a lot of people about this case. You'll be shocked. Current DAs. I have not talked to anyone who thinks that count 1 and 3 make sense, and that's the murder count and the hit and run causing death. I have not seen anyone who can explain to me why they charge those counts. I still don't know. And at the end of trial 1, when I still didn't know, I was like, are you fucking kidding me? Why did you charge this? Go with count 2. They should have offered her a plea to count 2 if they truly thought that she was drunk, that she was driving, and that she had some responsibility for his death. But no one can explain it to me. And the only arguments I've seen online about it are driven more by emotion than by the evidence. Count 2, it's hard for me after the last trial, but I can make an argument for count 2. I can see how a jury can get there. But I can't see how you get to count 1. I don't see how you get to a volitional homicide. I don't see it. And I think it's overcharged. So, yep, that's where we're at. All right, let's continue on. Let's continue on, shall we? So this is the argument over third-party culpability and the defense wanting to bring in the Bowden defense, which is law enforcement should have investigated others.
A feud or tough relationship. I saw on a video that there were 2 radio personalities, and I have the clip, who spoke and met with Karen Reed, and during the conversations, at least they relayed, that there was some claims about drug issue, and according, not to the defendant, but according to the interviewers who supposedly interviewed her, they said that the story is complete.
The interviewers who supposedly interviewed her? Seriously, Brennan? There was an interview. What? There was an interview. What does supposedly even mean?
Completely false. They attribute this to Karen Reed. People are trying to make it more dramatic, like Colin would have a reason to hate John O'Keefe. That never happened, referring to some drug claim. He did not report him for anything. And so what we know is there is no history of animosity between Colin Albert and John O'Keefe. We know that there was no animosity between his family and John O'Keefe. The only event known is that at some point, Colin Albert's younger brother ran across John's lawn.
That might all be true, but he was there and nobody disclosed that he was there. So isn't that at least a trigger to investigate a bit if there's any connection between the two? You don't really know if there's any connection between the two because no one investigated it. And that is the basis of a Bowden defense. Would more be known if it was investigated? Why did no one say he was there?
Mr. O'Keefe supposedly yelled at him and then bought him candy as an apology.
Oh, my
That's
bad.
it.
He's not
So
saying.
we
He's not saying supposedly. He's saying supposedly. My vocabulary gets stifled every time I listen to you, Brennan, and it's the height of hypocrisy coming from Emily D. Can't Pronounce Words Baker. The height of hypocrisy. But also, sir, it's a nefarious pronunciation of supposedly. He's still on 1.25.
an alleged third-party culprit, a very strong claim, with no evidence. No motive, no opportunity, not even present at the time that this alleged collision occurred. And so in that absence of evidence, it's not even feasible. Colin Albert should not be brought to the stand, attacked with acts that didn't occur, that otherwise would have no admissibility. Really, it seemed to be a backdoor way to tarnish his reputation and then bind him with other people the defense would like to attack to make a general suggestion that somehow this group of people are bad people. I know at the last trial, there was pictures of Colin Albert's knuckles that were scraped.
The argument is law enforcement should have investigated. I think the defense also definitely takes their opportunity in the media to say everybody's bad people. But when we get to trial, the argument should be they should have been investigated. That's
And inevitably, it turns out that picture, and I think the exhibits were introduced at trial, was taken much later. Pictures taken before that point show that Colin Albert's knuckles on the 9th and 11th of February weren't scraped at all. So because he had scraped knuckles subsequently, because he may have done a video that some use would maybe do and threaten somebody else, not John O'Keefe, has nothing to do with this case whatsoever. It's an attempt to introduce alleged aggression or prior bad acts. But
it's disingenuous because the reason a lot of that came in the first trial was as impeachment. So it came up for impeachment purposes based on the answers of Colin Albert. That's why it came up.
No bind whatsoever. The second person that the defense would like to identify as a third-party culprit is Brian Albert. And this is some of the gross generalizations that you see with Colin Albert. No specificity, but trying to assault his general character by generally suggesting things that may or may not be accurate and just telling part of the story. They claim he didn't have a good reputation among fellow police officers. No evidence. They claim it. And even if it was so, it has nothing to do with this case. Known as a bully, so rumor clearly is not admissible in a criminal case. Had a history of sucker punching officers. We don't see any specificity. We don't see any evidence. We don't see any information. We just see a general attempt at a character assassination to portray him as somebody who is either capable or a bully. Nothing relative to John O'Keefe. Nothing. They suggest, and I'm not sure what the basis for this is, that he was drinking heavily that day.
You guys are saying you're getting an echo. I don't hear an echo on my end. Miguelina, are you? I am not hearing a lot of an echo, so let me see if it tamps down because I am not hearing it on my end. You guys keep me posted.
When he went to a funeral with Mr. Higgins and another person. It is true that he was at the hillside around 9 o'clock and was drinking around 9 o'clock. So all of this information is just general inflammatory accusations about character. They say he was a trained boxer because when you were...
All right, let me try to change, because apparently streaming is dynamic and the settings aren't helping me. Let me try to change a setting real quick and hope that that will take care of it and not impact the sound. Let me know. It might be court.
Worked out, he boxed and he was engaged in charity events, some dating back to 2003. By that standard, anybody in the neighborhood who has any self-defense training, mixed martial arts, or boxer would be on the target list. The fact that he is a police officer and that he is physically fit and that he trained to protect himself doesn't make him a third-party culprit. It is this general suggestion of strength and distorted into a hopefully perceived sense of violence that it has no root at all, no root. They went as far to say he was investigated.
All right, and now, again, streaming is dynamic. All right, let's try to fix it again and see if that helps. All right. Traveling is such a party.
By BPD for violent conduct, but they don't give any details. If they looked, they could go online, they could investigate potentially. There is no sustained findings that are known to the Commonwealth against Brian Albert in internal affairs, none whatsoever, ever. And so to make the suggestion he was investigated by BPD for violent conduct, they provide no fact.
All right, give me 1 second.
I'll say, even though it is off base entirely, it has nothing to do with John O'Keefe. They're trying to suggest that he has a propensity for violence. And they don't do it very well because they provide no details. These are all just general accusations by the defense. In fact, I would say it's not permissible. You can't bolster the good character of a witness, but to simply make suggestions of bad character is not any root or tethering to this case specifically. Instead of bad character, Brian Albert was a two-time recipient of the George Hanner Award, has many, many medals of honor from the Boston Police Department, but that is not the issue.
Tara asked real quick how much gear I travel with to stream. I travel with a lot of gear to stream, but it also helps me mask the fact that I'm a habitual overpacker, so I feel like I have an excuse, so it works for me. But it is stuff.
They suggest that he was involved, so they know that they have to tie him not only to the scene, but somehow to Mr. O'Keefe, and other than being at the bar that night and Mr. O'Keefe and Miss Reed pulling in front of his property that night, there is no association between the two. They say he's present at the scene of death. By all evidence, Mr. O'Keefe died feet from the street, near the flagpole in front of 34 Fairview. So that's a little bit broad. He wasn't present at the scene of the death. He wasn't there. And that happened out front, on the front yard near the flagpole, about 70 feet from his house. The body was found feet from his front door. Arguably, okay, 70 feet, 75 feet. He admits to being home. He doesn't have to admit he was home. Now here is another claim without any evidence whatsoever. The defense states emphatically, computer forensic data overwhelmingly establishes O'Keefe entered Albert's house. I haven't seen that evidence. Based on what? So if they're going to make an offer of proof to the court, and they're going to make claims to substantiate this theory, they have to have proof of it. And in their motion, I see no proof whatsoever that overwhelmingly establishes John O'Keefe went into the Albert house. In fact, what we see is the opposite. In the past trial, numerous people were called. Every single person that was asked stated they did not see John O'Keefe enter that home. Every single person. Now, whether you believe it or not is irrelevant. What's relevant is there's nothing to the opposite. There's an absence of evidence to the opposite.
If it's not believed by the jury, it actually does. It does matter.
In fact, the phone data and the Waze data and the GPS and all the data puts John O'Keefe at the front yard, not in the house. So if they're asking the court
My in-ears just fell.
to make a finding of substantial link and substantial proof that John O'Keefe was in the house, they have to actually give you the facts and the science and the data to support that, and I don't expect that will happen. They add that there was going to be expert testimony that the scratch on John O'Keefe's arm was from an animal or a large dog, and because Brian Albert had a dog in the house, there was some type of inference. Dr. Russell has already testified at the Lanigan hearing that she's not saying that those bite marks were from Chloe.
Well, nobody's going to
Although
say
it's not
that
been
from
decided by
Chloe
the court,
specifically.
Dr. Crosby has done molds that show that the
Obviously.
teeth comparison is totally an opposite. And so even the defense is not saying, as I see from the disclosures, that Chloe bit John O'Keefe. Their version, which we don't agree with, is that a large animal or a dog caused these wounds. They don't say where, they don't say when, they don't say how. And so that is not a link so that Brian Albert becomes a third-party culprit. Finally, in a way to try to create some type of traction against Brian Albert, they associate him with Brian Higgins because they spent the day together, because Brian Higgins, according to them, was rebuffed, because of phone calls at night. All of these general claims with no fact predicate rely on innuendo, surmise, speculation, or just the creation of an inference.
You know what might help with the innuendo and surmise? If everyone's cell phones weren't rehomed the day before they got preservation notices. That might help a little bit. But the rehoming of the phones is fucking weird. It's weird. The jury can make deductions from that. It's in the jury instructions. It's strange behavior. It seems almost intentional.
It does not exist. There is no evidence Brian Albert had any motive whatsoever to harm John O'Keefe. None. There is not one witness, there's not one statement that Brian Albert had any animus whatsoever towards John O'Keefe. None. He did not have the motive. He did not have the opportunity. And there was no evidence that he was involved in any way in the alleged collision that happened in the front of his yard that night. Finally, the defense turns to Mr. Higgins. Mr. Higgins was at the Albert address that night. John O'Keefe never went into the Albert address that night. They take very, very select pieces of information. I would suggest don't tell the whole story. And from that, they want us to speculate a motive. For example, they say that Karen Reed...
Excuse me, Pot? Have you met Kettle? Because, sir, you have not earned the audacity of your arguments.
...had kissed Mr. Higgins at John's house. That seems to be corroborated in the text messages. According to the text messages, Mr. Higgins essentially says that Ms. Reed came up to him and planted a kiss on him. And there's quite a bit of text message exchange that you heard during trial about that interaction. And then at some point, Ms. Reed went to Mr. Higgins' house. And so there was some interest, it would appear from the text messages, between the two. Mutual, at best. There's a plethora of text messages where Ms. Reed is pursuing Mr. Higgins, looking for his time, looking for his intention. In one, she says, basically begging him to come over. Do you like me? Come over to my house. There are text messages talking about Mr. Higgins not having enough time for her. So there is a flirtatious relationship between the two of them. What we don't see is that somehow that creates a motive for Mr. Higgins to want to hurt or kill John O'Keefe. The fact that they are texting together and later that night he sends a text message because I think an inference the defense would raise is that he felt like he was ignored or wanted to know what was going on with their relationship, is not evidence of motive. In all of these text messages, you never see any animosity towards...
But it's something that should be investigated. Like, it's something that should be investigated. It's something that should be investigated.
John O'Keefe. But Mr. Higgins' text messages are virtually all kind towards John O'Keefe. It's uncomfortable.
Oh,
it's an awkward situation.
Chat, y'all make an excellent point. Y'all make an excellent point. This is why chat is bae. The law nerd research attorneys are like, excuse me, sir. If her being upset that he's in the same neighborhood as someone he might have had a relationship with and thought that he was having an affair, if that's motive, then how is Higgins being like, WTF is up with us after having the most awkward text flirtation to ever happen? Why isn't it same? Excellent point, chat. Excellent questions.
Situation because both of them appear to be deceptive as it relates to John O'Keefe, but there is no vengeance, there is no anger. And so the suggestion that there is a motive because there was flirtatious text messages to then kill the man is beyond the pale. It's beyond any logical connection that would support third-party culprit.
I'm sorry, sir. I believe
Brian Higgins.
the witnesses you're talking about call him the guy. best of my memory.
Sent a text message saying to Ron, he asked him if he was coming to the home that night, and they then attached the word he lured them to the house. I mean, we do look at this evidence not in a vacuum, but logically and realistically. Not knowing that Karen Reed was not going to come in when they arrived at the house. Is it reasonable? Is it rational? Is it lucid to think that Brian Albert that Mr. Higgins was inviting them both over to the house?
My pump of mocha.
Not knowing only one of them would get out of the car? Is the suggestion that Mr. Higgins was going to kill both of them? Or he was going to kill one of them, so the other one he would then set up for murder so that he wouldn't be able to see her anyways?
Did he have opportunity? Did he have opportunity? Should it have been investigated? It's the question. It just is the question.
The absurdity of the relationship between the claim and reality is so great that it will just run rampant through this trial. It would be unrelated.
It would run rampant?
Speculative.
Really?
Shotgun approach to claims that the witness will spend their time trying to explain and defend. It will distract the jury, and it will serve the...
Are they trying to pull over the courthouse? Are they responding directly to the building? They're like, excuse me, courthouse, pull this shit over. It's so loud.
Purpose, which the case law says it shouldn't, of taking attention off the facts at issue for the case we're here from. And that attempt to divert anybody but the defendant is the attempt here. That's why we have three, we don't know who, but three potential third-party culprit evidences with absolutely fragile evidence. It's feeble. They, as their support, what they offer is they believe Mr. Higgins lied because he went to the Canton Police Department to do administrative work. And I think the evidence is clear that he had cars that he parked there as part of the job that he needed to clean off.
God damn it, Brennan. Look, there are a few things I am expecting from a trial in Massachusetts. And I am going to continue to be frustrated if they are not delivered. But if you can't even give us a great Massachusetts pack the car, like, what are you doing? Can we just get a full pack the car? Also, it's not that he went to do administrative work. You're killing me. The man drank so much that night and then went to local police station where he has like an outpost and then decided to move all the cars around. Night of drinking, goes to the police station, moves around the cars at 1:30 in the morning or whatever. Bro, come on. It's not as if he was like, oh, there's snow coming in. I'm going to go do that at 3 p.m. The behavior has context. This behavior is maybe not weird in the afternoon or even when they get back from the funeral. This behavior is weird after a full fucking night of drinking and then at 1:30 in the morning to pack the car.
So they are parsing words in an attempt to create a basis that doesn't exist.
Who's doing
that
what?
there are calls between Mr. Albert and Mr. Higgins later that night. So what? They have no evidence that either of them spoke to each other. They have
Because
no
the
evidence
phones are gone.
of conversations. They have no evidence of a conspiracy. They have no evidence of a cover-up. They have no evidence of a weapon.
Bruh.
What we know is John O'Keefe never went in the home. And so to try to create this image based on obscure facts is not the substance that's required under third-party culprit. I know third-party culprit is a time-honored tradition and is a broad latitude, but it's not endless. It can't prejudice the Commonwealth. It can't distract the jury. It can't be based on fiction. It has to be based on an identifiable theory. The cases that have allowed third-party culprit.
You know that, like, in criminal cases, none of it can be based on fiction, though, right? Because one of your witnesses in the last trial said that the crime scene spoke to me. Like, sir.
That have been reported have actual people who could be a third-party culprit, who actually have relationships to the scene of the crime or the deceased. In this case, an attempt to call Mr. Higgins a liar or create fictions about what they think he could have been doing or guessing what they want him to do is not evidence.
Guessing is not
9
evidence.
people testified John never came into the house. 9 people. There's no overwhelming evidence or any evidence he went into the house. There's no evidence of motive on any of these three people they identified. They've had, before the last trial, the entire trial, and was aptly pointed out, no request for a third-party culprit instruction. And then they had since then to make an actual proffer that people actually have the motive, opportunity, and intent to do this. That there's actual evidence that there's this alternative theory, and they failed to do it. They have the defense go through a trial, distract the jury, attack the reputation and character of the witnesses, and then not even ask for an instruction at the end.
Do they
evidence
have
the fact that there is no basis for a third-party culprit.
to show
Now,
motive,
separately,
opportunity
third-party culprit is part of both.
Bowden?
Even if the defense at the end does not warrant an instruction, I recognize that challenging the police investigation is virtually
That part.
an entitlement of a defense. How they do it and the extent they can do it is a different story.
Literally every criminal defense starts with the cops did something wrong. It's literally the foundation of every criminal defense. That is the beginning. The starting point is they did something wrong. It seems that Brennan has been arguing like this straight third party culpability and is now moving into the Bowden argument, which is, again, police investigation should have looked at other witnesses, et cetera, versus saying some other dude did it and it's one of these three. So he's shifted now into that argument, which is interesting to me because I think the Bowden argument is actually the stronger argument for the defense. And the court did say that third-party culpability could not come up in the first trial until there was evidence to lay the foundation to establish it. The defense brought a lot of information in as impeachment, not necessarily as third-party culpability. So they didn't argue third-party culpability the way that Brennan's arguing it at the end of the case, and I think we're going to end up at Bowden. That's where I think we end up in all of this.
Simply because they have an attack on the police investigation does not let them use third parties as part of that. And so the standard, Silva Santiago, is very clear, it's cited by almost every case, is that there has to be something the police didn't do at the time that they knew about and should have done. So at the time the police did their investigation is being criticized, they would have had to have known about a potential third-party culprit or third-party culprit evidence and didn't pursue it. And that's why the defense argument utterly fails here. Because at the time the police were doing this investigation, what they knew is that John O'Keefe was on the front lawn of 34th Avenue near the street. They knew that he was dying or is dead. And a number of witnesses knew that Miss Reed was saying, I hit him, I hit him, I hit him. A number of witnesses. Shortly
also had
thereafter,
an autopsy.
what the police knew is that Miss Reed's taillight was cracked.
They also had an autopsy.
And shortly after, what they learned and knew, after they got her car, is that part of her taillight was missing. So at that time when they were doing their investigation, there was no claim of...
How did all these witnesses know she said, I hit him, if it's not in any of the police reports? Do we know when they knew that? Do we know when they know that?
Highlights. That came months and months later. They went to 34th
They
Avenue
had
and they
the
spoke to the owner,
autopsy.
according to witness testimony. And everything seemed appropriate. Concerned, confused, no blood, no scratches, no cover-up, no turned-over furniture. There was nothing that would have alerted the police officers that there was any road to follow other than the road they followed. Now they can be criticized for plastic cups or leaf blowers, but that's different. That's different. In order...
They can be criticized over plastic cups or leaf blowers. I'm actually rethinking my feelings on the leaf blowers, but that's a different thing. The plastic cups, you're not going to convince me otherwise. But it's so far beyond that when you look at Proctor, which it's his argument. This is what he's going to do. But he's skating over quite a lot. And while I will give more latitude to the defense to do that, because again, the defense's job and the prosecutor's job are different, it rubs me very much the wrong way when the prosecution ignores bad facts instead of arguing why those bad facts aren't bad. He is doing the job of a prosecutor and arguing like a defense attorney, and it rubs me the wrong way so badly. You're not a defense attorney in this context, and you are acting like it. Stop it. You are ignoring so much. And again, I don't criticize the defense when they do this because it's part of their job. So I know there's people who are like, Emily is just like up the ass of the defense attorneys. No, I will call them out when they go too far. And there are times that they absolutely do. But the defense are zealously advocating for their client. The Commonwealth's job is to seek justice. It's a different job. It's not the same. You are not there to zealously advocate for an individual. You are there to put it in front of the jury and see if they agree with you. That's your job. But he cannot switch into the prosecutor role, and it's pissing me off a lot. It's just not what you are supposed to be doing. And any prosecutor that acts that way, I will criticize. And prosecutors that don't, I will point out. Erlinda Johnson wouldn't touch this case with a 10-foot pole, and that's purely my speculation. But when you look at prosecutors doing their job well, you're like, oh, they're just explaining to me what happened in the way that they see it. We saw this with the prosecutors in the Darrell Brooks case. It was a methodical, no drama prosecution. I mean, they also had a very factually supportive case. It was a very clear case. But they just went through, this happened, then this happened, then this happened, then this happened. What you want to see from a prosecutor is first this, then this, then this. This person did this person saw this person hid this. Or not hid this. This person saw this, did this, heard this. If somebody hid something, you shouldn't be prosecuting the case. But the heard and the did got all kerfuffled. So when you're presenting it, it is just who saw what, who heard what, who did what. And do those things show you that the defendant did the thing they're accused of? That's it. How is the defendant connected to the crime? What did the defendant do? What is the crime? That's it. And when prosecutors ignore that, it's just wild. And he's arguing like a defense attorney. And that really is, that's what's pissing me off so much. I don't think I've articulated it well previously, but that's really what's rubbing me so the wrong way, is he's defense attorneying the prosecutor's job.
In order to have third-party culprit under Bowden, the police would have to have known that there was information that targeted or pointed out a different person, and they didn't pursue it. So in the cases cited by both the Commonwealth and the defense, there are a number of cases that talk about information that was known to police at the time they were investigating and they failed to pursue it. That is not this case. That is not this case. There was nothing in any of these proffers that show actual evidence that the police knew of these later third-party culprit claims by the defense, or they knew at the time they were doing this investigation that there was any other lead. And likely the reason was because there wasn't. The evidence for a reasonable police officer pointed towards the statements.
Oh, good to know, Melissa.
Towards the light. And that was followed up, which led to DNA in hair and all the other evidence that followed the data.
We're watching
and so,
in real time.
As a concession to the defense, they don't simply get to...
Some of you are saying the echo is back. I don't have it on my end. I don't know if all of you have it on your end. I am wondering if this is a YouTube thing, because when there is an echo for the whole chat, I see it for the whole chat. If it's device by device, I would try very hard, not hard. I would try to just get out of YouTube and get back into YouTube on whatever device you are on, because it seems to be not everyone. It seems to be either your browser, your device, or your app. It's not everybody, but there is also some echo from the court, so it should pass in just a moment.
Bringing third-party culprit through Bowden because they failed in the instant case to show a third-party culprit. That's not part of their entitlement. And mindful that if they do raise Bowden, whether they get instruction or not, it is brought. And that means the police, including any police they would call in this case, or we would call, is entitled then to share their state of mind why they did and did not do something.
Yeah, they are.
That can open doors to inadmissible evidence, privileged materials, the state of mind.
Oh my goodness. Sir, here's the thing. The defense has already said, do it. Like literally do it. The defense is willing to open that door. Nancy Hall said, not a YouTube thing. I was watching this hearing yesterday and there was no echo. Interesting. I wonder if you were watching on a different device because we have half the chat saying echo, half the chat saying no echo. Hopefully it will shift. So we'll continue on. You guys are saying it's reverb. Fair enough. Let me slow him down and see if that helps.
The officer is relevant if they make it relevant. So we should not engage in a process where we allow witnesses to be asked questions with no ability of the defense to follow up those questions with actual proof. We should not engage in a process where witnesses, their character is attacked when it has no relationship whatsoever to this crime. And witnesses shouldn't be put through the ordeal of defending themselves based on generalizations about supposedly being violent or having a temper. There needs to be that nexus, and it fails. It is beyond feeble. And so I ask Your Honor not to allow third-party culprit in the instant, and you should not allow it as part of Bowden.
All right, thank you. Yes.
Hello, Mr. Yannetti. We're back.
No, the Commonwealth's motion raises.
We're back at normal speed with Yannetti. I might speed this up in a minute. They are still arguing the Bowden and third-party culpability that the defense wants to bring in. There is generally kind of a step-by-step, ooh, baby. There's generally a phased admissibility to this, where some foundation has to be laid in the evidence before they can get all the way into it. And I think that's what we'll see for this trial again.
Three interconnected issues, not just two. I believe that two of those were conflated by the Commonwealth. I'd like to separate them out. The first issue is the introduction or admissibility of evidence relevant to show that somebody else harmed John O'Keefe. The second issue, which I think was conflated with the first, is whether after the introduction of such evidence, the defense is allowed to argue that a specific person or persons caused John O'Keefe's death. And then the third issue is whether the police properly investigated this matter in light of the information that they had, or information they could have obtained or failed to follow up on to show that somebody else caused John O'Keefe's death. Regarding the first issue, which Mr. Brennan spent a lot of his argument on,
He did.
There is ample evidence tending to show.
I think the defense parsed that out well with the, Your Honor, we've literally got step one. I'm not going to stop. Where there are two parts to this. The third-party culprit, Your Honor, we can argue to the jury that some other dude did it, this person, this person, this person. Or the Bowden defense, which is law enforcement should have investigated these other leads and didn't. So there's two parts of it. Again, I think the second part of that is a stronger argument for the defense. They are arguing both, and they're focusing on Brennan's early argument, but this opens up for the defense to say, this is why we think there's third-party culpability here. So that's where they're going first.
That somebody else caused John O'Keefe's death. In our opposition, we have cataloged the evidence against each of the potential third-party culprits that we named the last time we were in court. Each one of them had a motive and an opportunity to harm John O'Keefe. The investigators in this case had evidence that pointed to Brian Albert. Brian Albert is a violent man. He was not only a boxer who punched people in the ring, he was also a violent drunk who sucker punched other police officers. Those police officers are on our witness list. He's been investigated by the Boston Police Internal Affairs for having done so. There are many police officers listening to this argument right now who are nodding their heads. We've heard from many of them.
Are they sitting in court?
It's undisputed
Can you
that
point them
Brian
out?
Albert was present at the scene of the crime. It was his house. He claims to have been sleeping merely several feet away from where John O'Keefe's lifeless body.
Brian Albert not coming out of his house is the weirdest fucking thing ever. It is the weirdest thing ever. It is the weirdest thing ever. I can't fathom, and again, after working as a DA for over 10 years, I know a lot of law enforcement. I can't fathom a scenario where there are that many police cars, ambulances, etc., that it's not bringing you out of your house to be like, WTF is happening. And I've seen arguments that maybe he didn't hear things because of the blizzard outside. Lights, man. Those are red blues flashing all up and down that neighborhood. So even if the sound didn't get picked up, the lights flashing would have woken somebody in the house up who would have been like, what's going on? There's law enforcement outside the house. That's weird in a blizzard. Or the dog would have been going nuts. Look, man, I am a cat person, but the dog's not concerned. The dog's not concerned. Really? I can't imagine a scenario where someone doesn't come outside. It's just very, very odd to me. It woke up others in the neighborhood. That no one in the house woke up. It's odd.
He was later found. There is evidence that John O'Keefe entered Brian Albert's house. The Commonwealth may not agree with that interpretation of the evidence, but it exists. It's a live issue at trial. At the time John O'Keefe entered that house, an intoxicated Brian Albert was inside. He had been drinking day and night for hours at a time, and he was liquored up. He testified to that. He was at the hillside when he had his first.
I think that's the only response I would accept. I think that's the only explanation that would make sense to me. He was too fucking drunk. That's the only thing that makes sense. He didn't go outside because too fucking drunk. Let's see. Terry said, retired law enforcement here. There was a felony traffic stop in front of my house recently. And of course I was on the porch watching, even taking pictures. Right. Because you want to know what's going on. And sometimes, you want to know if anyone you know's there. Like, anytime something happened in my old neighborhood, I would pop out and be like, hey, who's working scene? Who's down the road? Especially if I wasn't going to cause problems. I want to see who's over by the house. Go say hi. Like, it's so strange. But I think I would accept. Too fucking drunk. I think I might accept that response. We haven't heard that answer in court. I don't know if that's the truth, but I think that's the only thing I would accept. However, nobody seems to be self-conscious about their level of intoxication because they rolled up to the station moving cars around. So, Jennifer said being nosy is human nature. We love it. Yes. And again, if law enforcement's on your lawn, and your law enforcement, you're going to go out and go, what's going on? What happened? Tell me everything. It's strange.
Drank in the afternoon, and he testified under oath he was drinking consistently the entire rest of the day and night. The Commonwealth says that every single person didn't see him in the house. Those same witnesses that the Commonwealth points to, every single one of them also did not see him on the front yard, where Mr. Brennan claims that he was at the relevant time period. That day and night, Brian Albert was attached at the hip to his close friend, Brian Higgins. This was the night that, after having carried on a flirtation with Ms. Reed while she was dating Mr. O'Keefe, Brian Higgins was confronted with Ms. Reed and Mr. O'Keefe together. In the words of one eyewitness, Ms. Reed and Mr. O'Keefe appeared to be lovey-dovey that night. Higgins had expressed his...
Again, the Colaketheses were just like, they seemed great. I feel so badly for those that were local and went to a basketball game and ended up having to testify in this trial, because you never know when a normal night is going to no longer be a normal night. But that was the description, is that he and Karen were lovey-dovey. But when you hear what Karen said in her interviews about the fact that she and John had been fighting, and she was mad and she was frustrated with him, and they were having stuff in the relationship, it also makes sense to me that you go out for a night and you're like, we're just gonna have a nice night. I just wanna have a nice night. We're gonna hug, we're gonna smooch, we're gonna drink, and we're just gonna try to put it aside and have a nice night. Like, I get it. I get it, especially if she was feeling a little bit jealous, because I'm not gonna say that sometimes people don't play up their PDA if they are feeling some kind of way. I mean, I would have never. I'm just saying. Does this explanation shock me? No, it doesn't. Especially if she wants to make Higgins jealous. And the chat's bringing out she was feeling unloved. Right. If she's feeling unappreciated, you're going to have a night with some PDA. I get it. And I think most of the jurors would get it too, because of all of the odd behavior that happened this night, the behavior that tracks a lot for me is Karen Reed's behavior and John O'Keefe's friends that went with him to CF McCarthy's and then went over to the waterfall. Those behaviors track for me. The humans are humaning. The behaviors that don't track are the butt dials, the rehomed phones. When you just look at it from that, what behavior makes the most sense and what doesn't? And then you try to make sense of what everybody's doing in light of excessive drinking. And again, excessive is not a judgy word from me. It is a lot of drinking. However, this is a group that seems to drink really regularly, so maybe it's not a lot for them. Everyone's threshold is different. There's a lot of alcohol involved. Like a lot of alcohol involved.
His interest, but it went nowhere. And it went nowhere because prior to January 28th of 2022, Ms. Reed had rebuffed him, essentially ghosted him. She stopped returning his messages.
His texts were cringy
Brian
as fuck.
Higgins was liquored up that night as well.
She ghosted him.
They're both very large men. The court saw them on the video. Friends who drank the entire...
Again, the relational level between Reed and John O'Keefe is not what is on trial here. I still have a hard time getting past the autopsy.
Day and night, they were waiting in the house for Mr. O'Keefe to arrive. Mr. O'Keefe ended up dead because he went to Brian Albert's house. After Brian Higgins left, Brian Albert maintained contact with him.
It might not be true
At
in the way the defense
2:22 in
is
the morning,
arguing,
the two of them were exchanging phone calls to check in with each other just a couple of hours after Mr. O'Keefe.
That would also be a great line for opening because literally true. John O'Keefe ended up dead because he went to 34 Fairview that night. It's not arguing third-party culpability. That's what the evidence will show. He ended up dead because he was at 34 Fairview, because he's not going to die of hypothermia at his home.
He was mortally attacked. Mr. O'Keefe had dog bites and or scratches on his arm consistent with a dog or an animal attack. Brian Albert had a large German Shepherd who had attacked and injured somebody in the past. It all fits. The Commonwealth utterly failed to investigate Brian Albert as a potential suspect. And I'm sure the court remembers the words in the text message of now ex-trooper Michael Proctor, the lead investigator who...
He enjoyed saying that a lot. I'm just going to back it up. I'm just going to back it up. I'm just going to back it up. I have no shade for the defense in their delight to see what happened to Michael Proctor. I think that a lot of law enforcement looks at Proctor's behavior and is like, yeah, he should be fired. Like, there are things people should be fired for. And Proctor fell in to that category. You got to get rid of bad officers before they become worse. You have to.
Brian Albert as a potential suspect. And I'm sure the court remembers the words in the text message of now ex-trooper Michael Proctor, the lead investigator who's now been fired as a result, in part, of being biased in this investigation.
Oh, the dramatic pause.
I would point out also that
Wait!
when Mr.
Read the
O'Keefe
text!
was in the house,
Damn it!
both Brian Albert and Brian Higgins were unaccounted for.
I was waiting for that to
according
finish.
the
It didn't
testimony.
finish.
With regard to
Yannetti, you left us hanging.
Michael Proctor's words,
We've been left hanging.
he was asked specifically if the homeowner would catch any grief for having
Oh,
a
there it
deceased
is.
person
We
on
came
his
back.
front yard.
We came
And
back,
Michael
okay.
Proctor said, nope, the homeowner is a Boston cop too. The message was clear. If you're a suspect, you get fully investigated unless you're on the right side of the blue wall. If you're a police officer...
That text message is very good for the defense because it leans into the argument of what law enforcement was going to or was not going to investigate. And the friend chat with the group chat with, oh, the homeowner must be shitting themselves. I'm paraphrasing because Boston cop ended up on their lawn dead. The homeowner must be shitting themselves. And the response is, nope. Homeowner's a Boston cop too. There's a lot of room to argue that that means he's not going to be investigated and he's not going to get in trouble. And I think that's a reasonable argument for the defense to make. And it underlies the police were never going to investigate the homeowners.
Officer, you get a pass. Now, in addition to the 2:22 a.m. phone calls with Higgins, there's other consciousness of guilt evidence implicating Brian Albert. And I would note, this is not something that Mr. Brennan addressed in his argument. He did talk about the consciousness of guilt evidence. Despite a massive police presence on his front yard, just feet from his bedroom, Brian Albert never came out to speak with investigators.
It's weird.
And it's worth noting, it's worth stressing, that Brian Albert was a first responder. He chose to ignore his duty to help somebody in need and instead stayed in his bedroom. And Brian Albert's dog, the family dog, a member of the family for 7 years, Brian Albert got rid of the dog, shipped it to another state, only after it was made known in court that the defense was alleging that the dog had been involved in the attack on John O'Keefe. We showed photos of John O'Keefe's arm in a public hearing where it was clear to any unbiased observer that Mr. O'Keefe suffered those particular wounds from a dog or animal attack. Brian Albert responds to that allegation by essentially divorcing his family from their beloved dog, whom they had had for 7 years and certainly considered to be a member of the family. In the aftermath of John O'Keefe's death, Brian Albert went so far as to send that family member to another state. That's enough evidence to point to Brian Albert as a potential third-party culprit in this case. It's evidence that he had the motive, intent, and opportunity to hurt John O'Keefe. Brian Higgins is another potential third-party culprit. Like Brian Albert, Brian Higgins was present at the scene of the crime. He was there at the relevant time, in the house, again, unaccounted for, at the same time John O'Keefe would have been there. Brian Albert had cause to back up his friend, but it was Higgins himself who was the one who had been flirting with Ms. Reed in the weeks leading up to January 29th. He testified that she kissed him goodbye after they had watched an NFL playoff game at a get-together not long before January 29th. He testified that she had visited him at his apartment after that, but he acknowledged that their text exchange and all contact between them ended, and Ms. Reed was the one to end the contact. She stopped responding to him. She no longer gave him any attention. So we come to January 28th. Brian Higgins sees Ms. Reed in person, but she's not alone. She's instead with Mr. O'Keefe. Ms. Reed and Mr. O'Keefe are affectionate with each other that night, and Higgins is there to see it, as is Brian Albert. There's evidence that Mr. Higgins wants Mr. O'Keefe to come to the Alberts' house that night. In fact, he appears fixated on making sure that Mr. O'Keefe went there. In the waterfall video, Your Honor, you will see that Higgins motions to Mr. O'Keefe when they're leaving. And Higgins even texts him directly after that to make sure that he was coming. Then Higgins goes to the Albert home. John O'Keefe goes inside. Higgins is there waiting for him, with both the motive and now the opportunity to hurt John O'Keefe. Like Brian Albert, there's evidence of his consciousness of guilt as well. After a long day of driving and drinking, Higgins leaves Brian Albert's residence, does not go home. Instead, he goes to the Canton Police in the early morning hours. He initially claims he went there to do administrative work. He changed that testimony at trial to him going there to move a vehicle. But he's always maintained, including in the first trial, that he never called anyone. We've learned since that trial that Higgins is at the station on video making a phone call. So I suppose the question is,
where was that video?
Why did he lie about that? The jury in this trial should be entitled to consider the answer to that question. And of course, the police never investigated who he was calling or what he said or who was calling him. Then he goes home and he still stays up. And at 2:22 in the morning, he's speaking by phone with Brian Albert. And he claims that they didn't, but the phone records don't lie. And this notion that these two men are somehow able to butt dial and butt answer each other is just ridiculous. And there's more consciousness of guilt evidence with regard to Higgins. When he realizes that investigators might be interested in the contents of his phone to see what evidence might be on it,
Yoink.
he demonstrates consciousness of guilt by getting rid of his SIM card and the phone itself. And how he got rid of it was extraordinary and demonstrates just how badly he wanted to keep that information out of the hands of investigators.
Yeah, that phone was gone.
He admitted to breaking the SIM card into and making a special trip to a military base to put this tiny object, the size of about a thumbnail.
He said it wasn't a special trip. He said he just happened to be driving through the base and decided that that was the perfect place to dispose of it. You know, a place that law enforcement can't just access.
Into a large dumpster. It wasn't enough to throw it in a waste paper basket or a trash bin outside the local Dunkin' Donuts. Instead, he went through security at a military base and secretly tossed this tiny broken SIM card into a dumpster. He made sure that investigators would never know what's on his phone, and he admitted to that at the first trial.
It's true.
And of course, the investigators in this case, including the lead investigator, former trooper Michael Proctor, never showed any interest in Higgins' phone. Higgins nonetheless accomplished his goal of keeping the contents of the phone out of the hands of the defense in this case. That's powerful evidence of motive, intent, opportunity, and consciousness of guilt of Brian Higgins. As Mr. Brennan acknowledges, all doubt should be resolved in favor of the admission of third-party culprit evidence, linking him to the harm caused to John O'Keefe. And finally, Colin Albert was a potential suspect. He had been in a feud with John O'Keefe. He'd thrown beer cans in his bushes, told him to F off. We have a good faith basis to claim that. This is the same Colin Albert who testified under oath he had never been in a fight in his life, yet there were videos of him clearly desperate to beat up others. The same Colin Albert who had scraped...
I have a little more patience for, he's saying he's never been in a fight, and then there's video of him blustering on Snapchat. I don't know, man. He is a juvenile. I am not overly persuaded by the video of him acting like an idiot juvenile. It also seemed in that video that he was drinking. But the knuckles is a weirder thing for me, but I'm more persuaded on the other two than juvenile blustering for me. When you're talking about what Higgins and Albert were doing, I am more persuaded than juvenile nonsense.
Picked up knuckles just a few weeks.
The knuckles are weird.
After John O'Keefe's
But again, it's a few weeks later.
Knuckles looked consistent with an attack on somebody. The photographs that Mr. Byrne references that were allegedly before that photo had no metadata. We can't confirm when those were taken. Mr. Byrne wants us to just accept the testimony that they were taken before the scraped up knuckles photo. We don't buy it. We don't think a jury will buy it.
Oh, I agree. The knuckles.
When John O'Keefe was found, he had two black eyes looking like he had been punched in the face. Colin Albert was at his uncle's house with both his uncle and Brian Higgins, disliking Mr. O'Keefe for a different reason, but disliking him nonetheless. And it's suspicious that Colin Albert's name was purposefully omitted out of the police reports. There was no indication in any police report provided to the defense in the first few months of this investigation that Colin Albert was anywhere close to 34 Fairview, his uncle's house, on January 29th. In fact, there's no indication in those police reports that Colin Albert even existed. Initially, we didn't even know who he was.
Which again, with Colin Albert not being mentioned in any of the reports, I'm more curious about what he knows, and why he was never mentioned. I'm more interested in that, truly.
But we found out when we sent a letter to Mr. Lowry, while the case was still pending before a grand jury, notifying the Commonwealth that Colin Albert should be called as a witness.
Ashley mentioned in the chat, and I just wanted to bring it up because I don't know. It said, Emily, he's in an orange jumpsuit for Halloween with a teardrop under his eye. Look, I don't know what he dressed up as for Halloween or what he didn't. I'm just going to say I worked in juvie for a minute. Kids who are hard for one way or another, or for one reason or another, aren't dressing up for Halloween trying to tell you that they're hard. So it for me, it just cuts against the fact that he's actually some type of true, I don't know. I don't know the kid. He, at all of the times this was going on, he was a juvenile. I don't know if he's still a minor rebel duck or not now, but he was then. But what he dressed up as for Halloween is, again, maybe more persuasive if he was being cast for a reality show, not super persuasive for me for trial. The knuckles is weird. The never been in a fight is weird, but the rest of this stuff, why wasn't he questioned as a witness? That is more interesting to me. That's really more interesting to me.
Before the grand jury. It was only after we sent that letter notifying the prosecution that we were on to Colin Albert that testimony was elicited that Colin Albert was indeed at 34 Fairview that night. The defense caused this to be revealed, not any investigator of this case. And there's obviously an inference that his name was kept out of the police reports to protect him. The same way Brian Albert is the only person listed in the initial report whose first name is not even spelled out. He's just listed as B. Albert with an incorrect address. There appeared to be a conscious effort of these investigators to hide third-party culprits from the defense. All of these men, Brian Albert, Brian Higgins, Colin Albert, were present at 34 Fairview. the night that John O'Keefe was killed, and each had a motive, intent, and opportunity to cause him harm. Now, there are many cases, Your Honor, I know the court is aware of this, endorsing the admission of third-party culprit evidence. Almost all of them allowed in a third-party culprit defense, despite a lack of evidence that the third-party culprit in those cases was actually at the scene of the crime at the relevant time. The first case cited by the prosecution, Compel versus Conkey, Middlesex County case, I remember it from the 90s. It was retried in the early 2000s. In that case, a person was murdered inside a home.
I love that.
Just like this case.
I was there, Your Honor. I remember.
Unlike this case, however, the defense could not place the third-party culprit at the home when the murder was committed. He lived down the street, and that was enough. Here we have hard evidence, irrefutable evidence, that the three potential third-party culprits were present exactly when the murder was committed. And it's notable that the defense in Conkey, in that second retrial, after the first conviction was reversed, the defense was allowed by the trial judge to present a third-party culprit defense, and it wasn't controversial. But the conviction was nonetheless overturned, the second conviction, on appeal, because the trial judge didn't let the defense go far enough in presenting that defense. The SJC ruled that in addition to presenting evidence of motive, intent, and opportunity, the defense in that case should have been allowed to introduce past sexual assaults of the third-party culprit, including one that took place 7 years before the murder. It was reversible error, not to permit a full third-party culprit defense, including prior bad acts of the third-party culprit.
That's interesting.
And I will ask the court to consider Commonwealth versus Finney, a case that I'm very well familiar, as I previously mentioned. I brought that motion for new trial. I argued before the Supreme Judicial Court, and I tried the retrial of that case, so I know it well. The SJC...
Your Honor, allow me to cite myself. This was my case. I argued it before the Supreme Judicial Court in Massachusetts. I did the retrial. I did the motion to dismiss. What that means is Yannetti was not the attorney who did the first trial. Yannetti, it sounds like, came in and did the motion for new trial and then took it through the appellate process and then the retrial. And again, I see a lot of you in the chat saying, this is the Yannetti that I like listening to. Yes, Yannetti is a little bit of shade, but just facts. The case law says this. The facts we're going to argue are this. It is a linear argument of what it is, with a little shade thrown at Proctor, but it's not the type of hyperbole that we've seen in other Yannetti arguments. It's a very focused argument and a very case law heavy argument, because it's clear that Yannetti feels that the case law is in his favor, and that is why he's really focused down. There are times when the defense spins out into nothing but hyperbole, and I think those are often times when either they're mad at the prosecutor and or the case law is not as much on their side. And sometimes in this case, it's not. That's just the case everywhere. In this, I think you see when they feel that the case law is on their side, how clearly he's arguing it.
He affirmed Judge Ball's allowance of the motion for new trial in that case, ruling that it was ineffective assistance of counsel that the attorney did not raise a third-party culprit defense. The case law makes clear,
which is interesting,
as Mr. Brennan again acknowledges, that this defense is a time-honored method of defending against a criminal charge. The defense should be given wide latitude to present relevant evidence that somebody else committed a crime. But
also, yes, it's legally a big deal if cases have been overturned on ineffective assistance of counsel, saying that the failure of the attorney to raise a third-party culprit defense is something that you can overturn a case for. And reminding the judge, Your Honor, if it's ineffective assistance of counsel, this is a almost fundamental part of a defense, and if you don't allow us to do it, it is reversible error. So why don't you just check yourself before you wreck yourself and not lean into potential error?
The main issue in Finney was whether the defense could introduce hearsay to support an already admissible third-party culprit defense. It's sort of like Conkey, where it's just assumed, yes, of course you can present a third-party culprit defense, but in Conkey, can you introduce unrelated sexual assaults from 7 years before? The answer is yes.
Which
And
is
in
also
Finney,
wild.
of course you can present a third-party culprit defense, but can you also introduce hearsay to support that defense? It was a given, and in fact it was reversible error that the third-party culprit defense was not brought the first time around. Mr. Brown talks about, well, you can't do this if it prejudices the Commonwealth. That's crazy. Every single time you introduce a third-party culprit defense, you are prejudicing the Commonwealth by definition. You're not.
The feed audio got worse. I think it will shift back, or at least I hope it will, because it was not this bad earlier. But he also moved away from the mic. So if the pool feed gained it up to still have him, that's why it's getting worse. It will get better, but it is not easy. And if I refresh on my end, we're going to lose it. But it's not just you, it's the feed. It's the feed. So.
Going along with their theory of the case. Mr. Brennan's aggrieved that we would deign to present this defense. And I would note, Judge, there's I believe a certain amount of gaslighting going on here in that on one side of his mouth he talks about he wants Ms. Reed to have a fair trial. But we've spent weeks where he's just trying to knock out all our evidence, just limit everything. He's I believe acting more like a defense attorney than a prosecutor in that regard. But regardless,
There's the hyperbole. Back to Yannetti being like, Your Honor, we have been gaslit by the prosecutor, and he has spent weeks trying to get rid of our audience, acting more like a defense attorney than like a prosecutor. That's what today was giving. The same. Today was giving exactly that. That's exactly how he was arguing today. You guys are asking me if I feel seen. No, it's just that's what the arguments are similar to. And it was hard for me to put my finger on it until we were watching his arguments today. And I'm like, you're not even making arguments like a prosecutor at this point with the amount of stuff that he was leaving out. So I'm not surprised that Yannetti sees it that way too. It's wild.
in terms of these cases, Mr. Brennan said that they all have third-party culprits who have relationships to the alleged victim and or relationships to the scene of the crime. Finney did not. In Finney, my client was the next-door neighbor. My client signed a confession to the murder. The third-party culprit lived several houses away within the same city, but not close, not next door.
Signed confession?
There was no relationship other than he made statements about how the victim probably deserved what she got and she wasn't the goody two-shoes, but there was no, that she was made out to be, but there was no witness that put the two of them together in any way other than those hearsay statements. Nobody put him at the scene of the crime.
It's an interesting case.
The SJC ruled even hearsay should be admissible to support that third-party culprit defense. The defense in this case has more evidence of third-party culprits than the defense did in Finney. We're not asking this court to allow into evidence hearsay, as was admissible in Finney. We're solely seeking to introduce the crux of a third-party culprit defense, which is evidence of motive, opportunity, and means, all of which Brian Albert, Brian Higgins, and Colin Albert had. That's the nuts and bolts of a third-party culprit defense. So that's the first issue, presenting evidence of a third-party culprit defense. The second issue is whether we can argue in closing that a third-party culprit is responsible for John O'Keefe's death. That's an issue, I suggest, that the court does not need to decide now in advance of trial. Closing arguments come at the very end of trial. At the charge conference, this court would be in a position, and would be entitled to evaluate the evidence as it came in and to make a decision at that time prior to closing arguments as to what we can argue and what we can't. And while we believe the court has enough evidence now as a result of the first trial,
That's a fair argument.
and as a result of our proffer and our submissions and oral argument today, to rule that a third-party culprit defense is permissible, that this court, at a minimum, should not deny argument on that issue before evaluating the evidence as it comes in.
That's fair.
And that brings us to the final third issue, a burden defense. Obviously, attacking the inadequacies of a police investigation is bedrock constitutional law. It's a bedrock constitutional right. In this regard, in one sense, the discussion about the third-party culprit evidence is somewhat academic as opposed to a practical one, because all of the evidence that points to Brian Albert, Brian Higgins, and/or Colin Albert, all of it comes in to show the lack of investigation, the lack of curiosity that the police had, and the lack of investigation that they did to rule any of them out. And it comes in to show the bias of the investigators of this case. Bias is also a constitutional right. They were perfectly willing to jump to conclusions about Ms. Reed, someone outside their law enforcement circle, on the wrong side of the blue wall, but very much unwilling to be curious about whether someone within their circle had the motive, opportunity, and means to hurt John O'Keefe. Former Trooper Proctor specifically told his friends he had no interest in investigating someone connecting with law enforcement. And in their internal affairs findings, his superiors noted that his apparent bias was one of the reasons he was fired. You can't have a stronger defense than that. So I would argue, Judge, that the Commonwealth's motion really comes down to what the defense...
And that's going to come in. It's going to come in because the investigations are all complete and he's been terminated. That's going to come in. And so when you look at the Bowden defense, and I'm not going to rehash everything I said earlier, I think it is a strong argument to streamline this case and say, look at what Proctor said, look at what he was terminated for, and look at the direction the investigation went, and lean all the way in to that argument for reasonable doubt. So I think that is, again, their strongest argument. And how much they lean into it, we'll see. But I think it's cleaner. But the Bowden defense, they are arguing at the end of this, the Bowden defense, I think the defense's main fight with the court on this is getting their expert in. And then getting into that third-party defense, because there are hurdles that have to be met along the way. And I think the court will allow them to make those arguments along the way. The reason that didn't happen in the last trial is because Lally never objected. And the defense was like, we're going to keep going. But I think in this trial, we will see it get staggered more, where we will see pauses where these arguments come up before the defense is able to get into some of these areas.
Will be able to argue in this case. Our position is we should be able to point the finger of guilt at those who might have done this, but at a minimum, given that the evidence will be coming into trial anyway on the Bowden issue, the court should reserve judgment on what we would be allowed to argue from now, weeks from now.
I think that's a good argument.
To our opponents.
Ask the court for something reasonable. You're going to get a reasonable
this
response,
evidence,
hopefully.
In conclusion, in our view, must come in. This is a due process constitutional right of my client, and it has to be admitted for two reasons. Number one, it's a time-honored method of defending against a criminal charge by pointing out that somebody else could have done this. And number two, it's a time-honored method of defending against the criminal charge by pointing out that police investigators failed to do their jobs correctly. We have a stronger third-party culprit evidence situation here than existed in either Conkey or Finney, and we assert it would be reversible error for this court to exclude
the light is changing outside, so
unless the court has
if
further
it gets
questions,
dark,
I would rest on my...
because I'm relying on the outside, and the outside.
Reed.
The outside's doing things. But we're going to see in this case that Brennan is going to throw up a lot more roadblocks and try to get into things that we didn't even see Lally fight with last time. And we're going to get a whole lot more of that this time, especially when it comes to like Karen Reed's statements and stuff. We've seen we've seen Brennan go after that with ferocity. And Lally was just like, So we're going to see really a very different trial, but the defense is going to have to take things in order and not just take things in order, but take things in order and then continue to argue them to the court. And I don't think that is wrong to go by phases. I think breaking it down is better and will be more clear. It also, if there is a conviction, it will give the defense a clearer record of what the court decided on, because the court's going to be asked to decide instead of things just happening. Brennan's responding because it's his motion.
I'm going to choose to focus on case law and the facts that aren't.
A fair bit of Yannetti's argument was case law. I'm going to focus on case law as if they hadn't. You didn't mention case law at all in the last part of your argument. They're responding to you. And they're responding to you when you said there's no facts and evidence of motive, opportunity. They responded with, but these are the facts that negate what you just said. And then to get up and say, I'm going to focus on case law. Sir, what? It's so frustrating.
Presented by the defense. We see in their motion there's a grand claim that there's extraordinary evidence that John O'Keefe went into 34 Fairview that night.
What case is that?
Critical.
Excuse me? What case does that come from? Can you cite me the case? Because you're focusing on case law. You have pissed me off so much today, Brennan. What is happening? I'm going to focus on case. Sir.
Because there is no basis to accuse somebody of murdering another person if they don't have the opportunity. In other cases, a third-party culprit is not necessarily found at the scene, even in Finney. It's more than just a couple derogatory words. In Finney, as counsel knows, there was a neighbor who had an axe or a club. He was seen with blood, went home, washed his clothes, wholly irregular, and because of this irregularity and the timing, he was then asked by his then wife about the victim, and he made a number of derogatory comments about her, showing ill will, evidencing, tangentially, motive. And so no, a third party does not necessarily have to be at the scene at the time the police investigate, but they have to be with the deceased if they caused the death. It's obvious. And so we didn't hear any extraordinary evidence, none. We didn't hear kind of good evidence. We didn't hear any evidence. We just have the bald assertion that the data forensic evidence will show that he was in the house.
Oh, it is?
It didn't. It doesn't. They don't have a proffer. So there is no opportunity to murder John O'Keefe when all the evidence points to him dying on the front lawn from an alleged collision. The defense's effort to tell a story, take a couple of facts, someone's a boxer, they drank alcohol, and convert it into a story, is how they will try to portray these unsubstantiated facts at trial. They'll tell a story. It will divert the jury's attention. So they're not entitled to it. They're not entitled to it. Time-honored tradition, yes, but there are limitations. Silva Santiago was very clear about the limitations. This latitude is not unbounded. Each of these limitations recognizes the admission of feeble third-party culprit evidence poses a risk of unfair prejudice to the Commonwealth. I'm not whining. The Commonwealth should not be unfairly prejudiced. The people of the Commonwealth.
Did he just say I'm not whining? This is a hearing from yesterday, and I feel like he was reading the chat. I feel like he was 100% reading the chat. I'm not whining. No one said the projection. No one said you were whining in court to your face. Did Yannetti once say, did I miss it? Did Yannetti once say that the prosecution is whining? Because I feel like I would have been like, damn. Maybe he did and I missed it, but Your Honor, I'm not whining. Conversations everyone has had with children. Okay, sir. I'm going to go off camera for a minute and because there is a storm coming on and try to find a light before I am just sitting in the dark. So I will be listening, but I will be turning on lights and hoping they aren't horrible.
Should not be
I had such a
unfairly
good plan.
prejudiced. Because it is inevitably, it diverts jurors' attention away from the defendant on trial and onto the third party. Essentially, it requires the Commonwealth to prove beyond a reasonable doubt the third-party culprit did not commit the crime. If there was evidence of third-party culprit, the defendant should be entitled to use it. In this case, there is not. There is no motive. There is no motive. To suggest that one person was pining, although the text messages don't show that, they both stopped corresponding with each other days before. To suggest that Mr. Albert is friends with Mr. Higgins and therefore he is bootstrapped into a conspiracy to kill with no evidence. Certainly the defense can infer certain facts like getting rid of the SIM card in a way they want, and I don't begrudge that at all. There's different interpretations to it. I understand that. This was heavily considered in the federal investigation, and after that absolute thorough investigation, there were no charges. There was no evidence of third-party
I mean,
culprit.
the light's not ideal, but
There were
it
no
is what it is.
indictments. And so, although we don't know the parameters of the federal investigation and we can only guess as to some of it, we know from what we did receive in review, it was thorough. And if there was third-party culprit evidence, we would expect that there would be a basis for it. It's not an entitlement to simply bring it in under Bowden. I don't defend that there was commentary in the officer's phone that was inappropriate. But that doesn't automatically create a situation where
You literally can't contend that Proctor's like doing the thing. Like, cannot. So, Chad, I'm sorry for the reflection that is inevitably going to be in my glasses from the light, but we're working with what we've got. So apologies. I know it's just a whole thing. I might have to go turn it off. It's making me crazy. It is. All right. I'll be back.
there was evidence that the police officers
I'd rather
knew
sit in the dark than this.
that there was somebody that should have been investigated. In fact, when Mr. Albert came down the stairs, the testimony is the police officer was already inside his home. There's no evidence Mr. O'Keefe, a first responder, was still outside that aid could have been rendered. That is just, it's not even speculative, it's just piecing.
Yeah, I'm not as persuaded by aid could have been rendered. I think it is factually true. I think the more significant thing when you are looking at prosecuting this case is the behavior and whether or not the behavior is consistent, inconsistent. But the defense argued a lot. Well, aid could have been rendered, which makes sense. But again, the behavior, it's worth questioning.
Together different facts and telling a story. So inevitably, while I recognize the case law, there are plenty of cases that talk about third-party culprits
Which ones are
should not
those?
be admitted if inappropriate.
Which ones?
Well, for Stedman,
Oh, he's going to
in that case, a
I'm actually interested to hear this.
person, not the defendant, was in a fight with a
BRB.
person at a campsite. And then later, the defense supposedly went back to the campsite, a friend of this person, Royal, and used a knife to stab and kill him. And the defense wanted to introduce prior convictions about the fact that this supposed third-party culprit had attacked people at other homeless sites. Pretty close relationship. A person having a history of attacking people at homeless tent sites. And the court, looking at 403, did not allow it as third-party culprit. They said that the admission would be feeble, pose a risk of unfair prejudice. In that case, there was third-party culprit admitted pursuant to Bowden in a very different way. Commonwealth versus Moore. The court would not admit layered hearsay showing different identifications
I know. Live court's
that
not as
were
much fun
relayed
without
by
the
the
EDB.
police from third parties regarding a culprit. They said that the hearsay was uncertain, the source is unreliable, and it was inadmissible as third-party culprit. So it is not an entitlement to be third-party culprit. Commonwealth versus Buckman,
That's
461 Mass.
Talk about
2011.
hearsay. Specifically.
The defendant was charged with murdering his wife. When they received a report from one of the defendant's friends, the defendant was softly tied to a pole to look like he had been kidnapped. Inevitably, the police determined that he had help or tied himself as a ruse. And this person, the helper, his friend, had connections to gambling, was there, and when the police couldn't find the body, he knew exactly where the body was. That case is far stronger than many. And in that case, no motive, no intent, and they did not let a third-party culprit defense go forward.
Okay.
Facts suggesting that one side believes a person's telling the truth or not is not facts of third-party culprit. It's just not here in this case. And again, I iterate my position on denying the defense to cross-examine witnesses about these generalizations and these character attacks. I think it will mislead the jury, and it will become a total diversion for the jury, and I don't think the basis is anywhere close. It's feeble.
Briefly respond.
Your Honor, we're not feeble.
First of all, Your Honor, speaking about the federal investigation, when you were not a part of it, and talking about why a federal grand jury was convened, what they were investigating, what they found or didn't found, is complete speculation. It should not be a part of this argument. We don't know. It didn't prove anything. It's not as though they came up with a statement exonerating anyone. So that should not be considered by the court. With regard to the two cases that Mr. Brennan cited, you'll note that in one, he talked about the exclusion of hearsay evidence. There's a different standard when you want to introduce hearsay evidence as part of a third-party culprit defense. There need to be substantial connecting links to the crime itself. The court ruled in that case there weren't. In Finney, there were.
That's different.
And with regard to the other case, that's with regard to hearsay. With regard to the other case, that was the exclusion of past assaults to show that somebody was violent. Again, Commonwealth v. Conkey is a case where they said, well, that should be, in addition to a normal or a regular third-party culprit defense, you should also be...
I did miss the prosecutor talking about the federal investigation, which is why when Yannetti was like, can we respond? I was like, what? But I did go mess with the lights and didn't hear it. But you cannot invoke the federal investigation because nobody has an answer to it. I will, I don't even know what Brennan is thinking, but that seems to be consistent today.
Entitled to that evidence, so that's not very instructive. The other two things I just wanted to point out, because I did not mention them, Your Honor, is that Brian Albert also disposed of his phone, and we'll never know what was on that. That's further evidence of consciousness of guilt. And then an important point is that the plow driver, Mr. Loughran, went by the house at 3:30 in the morning and saw a Ford Edge parked in the very area where John O'Keefe's body was found. And we know from the evidence that the Alberts, both Brian Albert and Colin Albert, owned a Ford Edge. So that is in the mix as well. Unless the court has any questions, I would rest on that.
All right, thank you very much.
Interesting.
So let's go on to paper 620, the Commonwealth's motion for production of records regarding
Oh, this is regarding the
unsolved
HBO special.
productions.
The court grants those. The court grants those. The laws in Massachusetts are different than in some other jurisdictions with regard to this. So the uncut interviews from the Discovery ID series that aired, I think it aired on HBO first. I don't know. I watched it on Hulu. I have no idea. But that, I think, will be given to the prosecutor, and I think it should be, given the laws in Massachusetts. All right. So let's see what he has to say about it.
Yeah. Yeah?
Yes.
Your Honor, the Commonwealth filed a Rule 17 motion for
Audience
records from unsolved productions. It has been discussed briefly in court at times during argument. There was a so-called documentary that was aired in a 5-part series. It gave a inside, behind-the-scenes.
The supposed interviews, the so-called documentary. It's a docu-series. I think that's fair. I don't know if that counts as a documentary. I don't even know what the definitions of things are anymore. But he's like, this so-called documentary. It's a true crime docu-series is what it is. But he's gonna get all the uncut stuff. So that's true. And Carol in the chat said, EDB, you rock. Well, thank you, Carol. Could not tolerate court proceedings yesterday. I know. Court without EDB is just no good. You add color to the mundane. Your honesty when you pitch a fit is so refreshing and makes the information presented exciting. I call it like I see it, and some days there is less to call than others, but whenever these arguments happen, there are things I agree with, things I don't, but he's going to get all of this information. So.
Look of the defense team and Ms. Reed as it prepared for the last trial. This 5-part docuseries produces a number of statements from the defendant.
Yeah, you're
many
gonna
of
get
them extraordinarily relevant. Some of them, from the Commonwealth's perspective, extraordinarily incriminating, and many of them inconsistent with statements made publicly in the past, including Dateline 2020 into Gretchen Voss. We served the local service in Boston, a local agent. The record holder is the producer of the series, and they have been notified. If the court allows this motion, I expect they will provide the information to us by the end of the week.
Oh.
I understand there is probably over 200 hours of recorded interviews.
Oh.
And we expect to use a number of those statements at trial. They are statements of the defendant, they're admissible substantively, they're admissible as admissions, and they're admissible to show contradictions with other statements. And so they are material and relevant. I understand the time frame. We haven't had the privilege of seeing them. The defense was there for a part or most of it, but we will use what time we can to sift through it. We're not looking for a continuance or additional time to look at the materials.
Yeah, I think he'll get these.
We'll look at them as we prepare for trial. And so I'm asking you to grant this. It clearly makes the Rule 17 standard material relevant. We don't have access to these before trial. We won't be able to prepare for them if we get them pursuant to a trial subpoena. They've been properly subpoenaed and they're forthcoming with a court order.
Yeah, I think that's fair.
Is there one here from Unsolved Productions opposed to this today?
There is
John,
not.
you asked a great question in the chat. I'm going to hold it till we get to Q&A because I want to give you a more thorough answer. It's a really good question.
We're not aware of the communications back and forth between the Commonwealth and the production company. So we've not been privy to that. This is the first we're hearing of any communications that they've had with the production company. I think obviously in an abundance of caution, they should be given an opportunity to oppose if they wish. Nothing officially has been filed one way or the other.
The production company would have gotten a subpoena, and if this was put on calendar with some advance notice, should have had notice to object, but the subpoena should give them notice to object. I don't think they're going to. And I think this will probably get turned over.
So we're not in a position to argue on their behalf, for sure.
All right.
Yeah, I think that'll be turned over.
So, we have two things left to
Fluorescent in the chat said, I have a feeling all statements will be used out of context. It's part of why they need all of the uncut interviews, because when the prosecution seeks to introduce statements of Karen Read made out of court, part of the argument from the defense, I would imagine, is, Your Honor, we need the full context for that. The defense cannot admit out-of-court statements of Karen Read. The prosecution can. And the defense argument is to make sure those statements are complete. If you only have the cut down version that aired, I don't think you can meet that completeness because you don't know if something was cut. I covered an interview back during the Depp Heard case, or after the Depp Heard case, when Amber Heard sat down with one of the networks, and we juxtaposed a sentence that had gotten like spliced or Franken edited, and in the previews, the sentence looked one way, and then it got edited, and then when it aired, the sentence looked completely a different way. So it was really interesting to see how the editing can change something. It's why I like this format so much, because we're just watching it as it goes. But it was odd to see how clipped it was, and even to change the sentence within the interview. So yeah, they need the uncut. I love all the uncut gems in the chat. The uncut gems. They are entitled to it. Massachusetts has very little protection for journalists, so I think they will end up getting this, just like they did for everything else. So look, when a party chooses to talk to the media, the prosecution, particularly in Massachusetts, has the right to access all of that. This would be very different if it was in New York or if it was in California or a different jurisdiction. Those are two I'm more familiar with, because everyone has different journalistic privileges. Massachusetts has very little protection, and there would be very little room for the production company to argue. They don't have to turn it over. They don't have to turn over their own work product, like their thoughts, how they edited, but they are likely going to have to turn over uncut interviews with the defendant. So when the defendant is on air, and then probably the interviews of the defense attorney too, because they chose to do that. Let's keep going.
discuss. I want to talk about jury impanelment. We also have a Commonwealth motion regarding Mr. Yannetti's Mr. Yannetti, it's 10 past 12. Which one do you want to go forward on first? Do you want to talk about the impanelment?
All right, two more things left for this
I'm
hearing.
not handling either of those.
I understand, but do you have a preference what's done before lunch?
I don't.
All right, so let's do that motion. Commonwealth's motion to compel communications between the defendant and attorney. So
The court is incredibly hard to hear today. This is going forward with the Commonwealth's motion to get communications between Karen Read and Yannetti. I talked about this a bit on the Emily Show podcast, which airs on Mondays. If you have the Lawnerd app, you just get it on the app. If you don't, it lives on the Quick Bits channel because it is quicker than a stream. So I talked a bit about whether or not Karen Read had waived attorney-client privilege in some narrow statements between her and Yannetti. And now whether or not that was waived is kind of part one, and whether or not they will turn it over is part two. So let us continue.
Your Honor, so I'm clear, the Commonwealth is not seeking all communications between Ms. Read and Mr. Yannetti. We're only requesting the communications that may be on any type of records in the possession of the Commonwealth. And specifically, there are phone records which have been redacted, and I do not know what is underneath those redactions. And we believe we have an entitlement to the information in the narrow area
Oh, look, how nice. The feed audio cleared up, or at least it sounds that way on my end. So hopefully it sounds better on your end as well.
where Ms. Reed has waived her attorney-client privilege. Specifically, where the defendant intentionally divulged the content of her communications with Attorney Yannetti about liability and potentially striking John O'Keefe with her car. Those subject areas in that narrow time frame are no longer privileged because they're now public. The Commonwealth has identified a very narrow window, and that's a 3-day period. And that is what is mentioned by Ms. Reed in her public statements, that she spoke to Mr. Yannetti and she thought about it for 3 days. We're not looking for any information beyond what has been waived. We're not looking for any information on collateral issues, and that's why we suggest that the court look at those records in camera, and the court makes the assessment whether or not the area where Ms. Reed waived her attorney-client privilege, whether any of those materials would similarly be waived because they are exactly related. This is made in good faith. Anything that is non-privileged is open to the public. It's not confidential. There are 2 communications that Ms. Reed made publicly that we assert waived the attorney-client privilege as it relates to that issue. Ms. Reed had an interview with Gretchen Voss on June 20th, 2023, and the transcript is page 105, line 23.
23.
She was asked the question by Ms. Voss, "You never said, 'Did I hit him?' I hit him." And the answer by Ms. Reed was, "I said, did I hit him, question mark. And then, you know, when I talked to David," now this is later, David said, "Karen, if you incapacitated him in any way, there's culpability there." And I thought, all right, maybe this is...
So she said it not just in the docuseries that just came out, but also in the June 2023, because that lines up similarly to what she said with the new docuseries. So that's interesting. Figuring out, Casey said, but David isn't her lawyer. David Yannetti is her lawyer. She's referring back to David Yannetti. So it's, those statements are similar. Interesting.
What maybe I said to my mother, just to go forward for a second, they were asking me, what was it like?
Different.
Did they come out? What was the house like? Similarly, in the documentary series, Ms. Reed is video and audio taped, and it was presented on television, that she said, "And then when I hired David Yannetti, I asked him those questions the night of January 29th, like, David, what if, I don't know, what if I ran his foot over, or what if I clipped him in the knee, and he passed out or went to care for himself, and he threw up or passed out?" And David said, "Yeah, then you have some element of culpability." So that's how I thought about it for about 3 days. And so that is where I get the time.
So we've got two different things here. First, can these statements come in at trial is different. So whether or not these statements Karen Reed made in the docuseries will be used against her, I think that they will. That is a different question. The question here is, did those statements made to Gretchen Voss and in the docuseries to the interviewer waive attorney-client privilege, which I think they may well have as to that narrow conversation? And then, did that waiver of privilege now entitle the prosecution to have access to statements in text messages or written communications that were on Karen Reed's phone between her and David Yannetti. So we're not talking about admissibility at trial. We're talking about whether there was waiver and then whether or not that waiver means that the statements get given to the prosecutor. And I should say, what if any statements, because what if any statements would get turned over, because Karen Reed's records have been redacted, and the redactions mean that they don't know if there are any statements that match.
Time period regarding these relevant statements, admissions by the defendant about her state of mind in her interaction with John O'Keefe in her vehicle. These statements were made during conversations that are obviously no longer protected or private or privileged. They're no longer confidential because they've been intentionally disseminated to the public. And so the defendant has voluntarily waived that privilege as to these communications in this subject area in that time period. And the key, Your Honor, is that it is the defendant herself who made the communications confidential. Even if it was inadvertent or overheard, it would still waive the privilege. This is entirely different. There can be no doubt that there was an intention to pierce that attorney-client privilege for whatever benefit the defense thought it gained them. This was intentional. It wasn't secretive. It wasn't overheard. It
I don't
was
disagree with that.
exacting and purposeful engagement. So we ask you to review the cell phone extraction, any texts or emails that may be on those extractions,
I don't like
and
that.
relative to that short window, relative to this specific area, anything that
I don't think this, I mean, I have never had this come up in any of my cases, because getting to attorney-client privilege communications is wild in the first place, which is why you don't talk about what your lawyer told you. But having the court review it and having that be the ask just does not sit well with me. I have not done the research. This is vibes. We're giving you Emily's legal thoughts on vibes. I don't like that the ask is to have the court review it. I think it would have to go to the taint team, have the taint team, not the court, see if there's any potential communications that line up between the two, and then have the taint team take those to the court and have the court review them after the taint team has said, yes, there are communications that match, or no, there are not communications. But I don't think you can have the court sifting through the communications between the attorney and the client when that is the court overseeing. I think if you don't want to send it to the taint team, then it needs to go to a separate judge. I don't think the trial judge is the one who should be making that determination at this time. It does not sit well. And again, I would have to go through the case law here, but that process, like what he's asking for doesn't even make sense. Asking for the court to sift through this, that can't be the right process at all, especially when these messages have already gone through, and I'm going to say taint a few more times, have already gone through the taint team. A team has already reviewed these to take out any attorney-client privileged information. So why ask to have the court do it? It almost, and again, this is based on vibes, but does the prosecution want the court to look through Yannetti and Reed's communications for some reason? I don't like it. I don't like it. I don't think any judge is going to say, yeah, I'm the right person to dig through this. When courts review records in camera to decide to turn them over, it's often not this. This is messy. It's an ask I don't like at all, and it feels wrong to me to ask this. But I talked about that again. If you watch the podcast, I talked about that on Monday when I recorded that with the members. I was like, I don't like it. Asking the court to do it isn't correct. Emily, can you cite to case law on that? Vibes, Your Honor, because vibes. But the vibe is off. The vibe is off on this, either a different judge or a taint team. This does not go to this doesn't go to the trial judge. Like, why the fuck would you even ask that? Why wouldn't you just ask for the taint team to review it? And then the taint team should say, yes or no, there are communications that match. All of this is weird. I hate it. I hate it. I don't like it. Privilege may have been waived. I don't know if that gets us to turning these things over. And I don't know why you asked the court to do it. It's also so strange to me with Brennan's background that he's asking the court to go digging through this. It's really an odd ask. Yeah, I don't like it.
It is waived.
I don't
That
like
is no longer confidential. We believe we're entitled to. It's obviously would be relevant if it's narrowly related to these statements, and we would use that at trial. Thank you.
I am, Your Honor.
Also, just because it's relevant and it's been waived, whether they get to use the statements is different than whether they get to whether they get access to what's in the phone dumps. I'm gonna refresh the browser on this because it's an easy point for me to find again when I refresh, because we've got Alessi getting up to argue, and it shifted just a little bit on the sound. So I'm gonna refresh this feed real quick. So again, we pick feeds very specifically for quality, for no scrolly banners and QR codes, and for closed captioning. But the audio shifted like 3 times while we were watching. So let me refresh one more time. And
David, what if I ran his foot over?
Thank you. We're going to fast forward past you a little bit to get to Mr. Alessi. You guys know what I think of the ask here. I think I've made that perfectly clear. I'm going to have to zoom a little and deal with the spinny wheel of internet doom. I have, Emily, you've flown too close to the sun, girl. What are you doing? What are you doing?
May it please the court. The Commonwealth...
That is, I need to close and open a different browser tab. Give me 1 second, you guys. Apologies. It's just, yeah, I need to open a new browser tab and hope that will fix it, because it got really overclocked on my end, and I want to make sure it's not a plugin that's doing it. So we want to have good audio. We do. There's only so much we can do when it's court, but I'm optimistic. Maybe I'm too optimistic. It's going to be low for a minute. Don't worry, I'll adjust it. But let's at least get back to where we were before. All right. Let's get dangerous. Emily, turn the closed captioning on. Stop singing.
Throughout
It's time to go to court.
motion as it must.
I know that the sound's bad. Give me a sec.
To intrude into our privileged communications between Ms. Reed and her attorney,
Where'd our
Mr.
closed
Yannetti.
captions go?
2 of the 3 instances of the
Why?
communication they cite to are over.
And now the closed captions. Good Lord. And now the closed captioning. You guys are like, sounds great. Perfect. And now the closed captioning doesn't want to pull up.
9 months.
If it sounds good to you, I'm leaving
and
it.
That's in 5 months old, respectively. So you have 9 months ago the Gretchen Voss
But
statements.
where?
And 5 months ago
There we go.
the Vanity Fair statements. But they waited until less than 2 weeks before the start of the trial to bring this momentous and potentially
Travel streaming
far-reaching and
is a
consequential
challenge.
motion. Why? The courts are clear that they take an extraordinarily dim view of parties waiting until moments before trial to raise significant issues like privileged communications this close to trial. the Commonwealth does not explain their delay in raising this issue this close to trial. With regard to the third communication, the HBO Max one, it regards the same event that is discussed in the first
timing
two.
is a good
There
argument.
is no addition of an event in the third one. So that third discussion, the docu-series, regards the same events that have been extant in the first two that have been extant for 9 months and 5 months.
It's a really good argument for the defense saying these are the same, and they really are similar statements, even if they're not exact, but why now? Why these communications? If they are essentially the same statements made by Karen Reed that were made 9 months ago, that's a really good argument. Why are you just bringing this shit up now? Why now? Why these texts? Thank you, chat, for getting the Legally Blonde reference.
The depth of this attempted intrusion by the Commonwealth should disturb and unsettle every citizen of this Commonwealth because they're either actual or potential clients of lawyers, and it should unsettle every criminal defense attorney in this Commonwealth. And I would dare to say,
I'm going to back Alessi up because he's taking shots at Brennan that are so smooth, you might not even see it. Just incredibly smooth arguments because Brennan is a defense attorney. So he's saying these arguments should concern defense attorneys that they are trying to get to the attorney-client privileged information. You should be disturbed. Not like down with the sickness, but like concerned.
Series regards the same events that have been extant in the first two that have been extant for 9 months and 5 months. The depth of this attempted intrusion by the Commonwealth should disturb and unsettle every citizen of this Commonwealth because they're either actual or potential clients of lawyers, and it should unsettle every criminal defense attorney in this Commonwealth, and I would dare to say it probably does. As we know, texts, emails, and written communications, exactly what the Commonwealth is seeking here, between an attorney and their client are canonical examples of privileged material. So what is at stake in this motion? What is at stake is the sacrosanct attorney-client privilege.
We went from canonical to sacrosanct, of course we did.
In Upjohn versus United States, the really bedrock attorney-client case from the U.S. Supreme Court, it established that dating at least from the age of Shakespeare, the attorney-client privilege is the oldest of privilege for confidential communications known.
Alessi, I think the chat would probably like you also to read us Shakespeare. If you're doing Shakespeare in the Park, just let us know, because I feel like most people can't wrap their head around the cadence of Shakespeare. There are times that I don't always wrap my head around the cadence of Shakespeare when spoken, but I feel like Alessi would get it like really well. Like I feel like he could get the cadence nailed. I'm ready for it.
To the common law, and this Commonwealth has identified that it is one of the most important, and it's been recognized in the Commonwealth as early as 1831. And in the context of criminal circumstances, the privilege has constitutional dimensions as well as it affects the interests of justice analysis that is documented in the Commonwealth v. Goldman case 395 Mass at 502. And it bears underscoring the basis and the depth of the intrusion is a quote from The very case and the only case that the Commonwealth cites in its motion. It cites one case in its motion for all of its propositions.
Alessi,
Just
they
one.
said they were just relying
Matter
on
of
case
a
law.
John Doe grand jury investigation 408 Mass 480. In the case at 485 states, as we have indicated, extraordinarily high value must be placed on the right of every citizen to obtain the thoughtful advice of a fully informed attorney concerning legal matters. A rule that would...
I also appreciate that Alessi has gone directly past, did she waive the privilege, to, should this be turned over to the Commonwealth? They are two separate questions, but we've moved right into, should these be turned over?
Permit or require an attorney to disclose information given to him or her by a client in confidence, even though such disclosure might be limited to the period after the client's death, would in many instances, we fear, so deter the client from telling all as to seriously impair the attorney's ability to function effectively.
Yeah, that's a big
concern. We think that the potential is inconsistent with the traditional value our society has assigned. Here's a key point. In the interests of justice, and that's the rooting of the interest of justice analysis, to the right to counsel and to an effective attorney-client relationship. Therefore, except where mandated by constitutional considerations, and it cites the Commonwealth v. Goldman, Super 395 Mass at 502, which are not a factor in this case, nor are they a factor in our, not a factor in that case, we conclude that the attorney-client privilege should not yield either before or after the client's death to society's interest as legitimate as we recognize that interest in obtaining every man's evidence. So the case the Commonwealth cites supports the protection of the attorney-client privilege.
That's kind of a
With that law jurisprudential predicate
Your
in
Honor, it's not
mind,
lawful.
I now turn to the statements at issue here and
he
their
was going the other way
import
around.
to that analysis.
You know what, Mr. Leslie, I'm going to stop you.
She is?
I understand the Commonwealth's argument regarding waiver.
The court does interrupt the defense quite a lot. Mr. Alessi, I'm going to stop you. Are you going to tell me what you are going to tell me? Are you going to tell me what you told me? Are you going to tell me what you're about to tell me? She sounds incredibly put out.
I understand that the request is now rotating, but I'm not going to give you this information, Mr. Brennan. I don't think it's appropriate for me to so
Well, there you go. She's like, Mr. Alessi, let me stop you. I don't need your entire dog and pony show. This isn't happening. Okay. I'm backing that up. I can barely hear the court because it doesn't sound like she's talking into the mic. I am backing that up to hear it again. Okay, Your Honor. The judge is like, what we're not going to do. Look at her ruling from the bench. Okay. She's like, we're not doing this at all. I'm going to just save your breath. We're not granting this. I don't need to hear anymore. We're not doing it. All right. I'm surprised. I'm surprised she ruled from the bench. I'm surprised that she cut Alessi off to rule from the bench. I'm not surprised by the ruling. I do think there's waiver here. I also think the court, at the end of the day, does rule in favor of the defense on some of the bigger issues because it is going to help if there is an appeal down the road. And we've seen that with the court really leaning in. There were plenty of times where the court could have kept out defense experts and didn't. So I'm surprised. I'm surprised she ruled from the bench. The ruling is not the biggest surprise because she has ruled in favor of the defense on some pretty significant issues, including their experts. So I'm not surprised by that. On some of the littler things, I know you guys think she is not seeing the defense the same way as the prosecution, not treating them the same way. I think we saw that when the court had grave concerns. But when it comes right down to these big rulings, a lot of them go in favor of the defense. And that has to do with appeal proofing your case. because if the prosecution wins, if Karen Reed's convicted, then appeal. If the prosecution it loses and Karen Reed is acquitted, then done. So there are definitely times where those big rulings go in the favor of the defense, but I'm real surprised it happened from the bench. I had to rewind. Wait, look at his face. That wasn't just my pause. He was like, what? His face has dread on it.
Mr. Leslie, I'm going to stop.
No, not dread. Dread and rage. He's like, you're interrupting me again. You're interrupting me again. You're interrupting me again. Look at his face. He can't read what the judge is going to do. He's like, fuck. He's like frozen.
I understand the Commonwealth's argument regarding the waiver. I understand that the request is narrow and tailored. I'm not going to give you this information, Mr. Brennan. I don't even think it's appropriate for me, so your motion's denied.
Boom. I'm not going to give you this information, Mr. Brennan. I don't think it's appropriate. Denied. Just, you have reached so far, Brennan, that the court has ruled from the bench. This judge ruled from the bench. Wow. I wonder how much the timing of it matters, because my thoughts on it changed. The second that Alessi pointed out, the Gretchen Voss interview was 9 months ago. That would have been the time to have this fight. I wonder how Alessi responded. I know all of you saying, I wish they had stayed on Alessi's face. Same. Because he must have been like, all right, I'm going to sit back down. The court's like, we're not wasting our time. Can we be done? Boom.
Thank you, Your Honor.
He's stunned silence. Thank you, Your Honor. We've never won that quickly, ever. I'm going to go sit the fuck down. I'm going to go win. I'm going to go sit down. Thank you, Your Honor. He's just like, what? That's interesting. All right, everybody's taking 5 minutes. Wow. All right. We're gonna zoom. Wait. Chat, can we just be internet detectives for a moment? It's normally something I frown upon, but I want you guys look, every now and then there's an exception for the rule, for me, not for thee. I get it, because there's times chat would do this and my moderators would be like, Emily, that's not the rule. I know. We're gonna divulge from our traditional rules for just a minute. Chat, what is Yannetti saying to Alessi? What do you think? Just what do you think? What do you think he's saying? We will just absolutely speculate wildly. What do you think he's saying? Drinks on me? We grabbing a whiskey? You've scared her so much she shut the fuck up? Like, what is he saying? What is he saying to Alessi? You scared her. Good job. What's your favorite whiskey? Though I don't know if Alessi's a whiskey guy, but what's your favorite whiskey? All right. Let's see. That was a very quick statement. I'm not going to take it. Emily, no, do not take it that way. Do not take it the wrong direction. But I think it was good job. Or, oh, wow. Could we see an oh, wow? I could see an oh, wow. Also, Yannetti was going in for the ear and he was like, there's a good girl. No, that's not what he said. Emily, stop it. Good job. He paused a minute before the whisper. We love it. I want to know so badly. All right, we are going to we're going to zoom past their court break as effectively as my travel internet will allow me to. That is not a 5-minute break by any stretch of the imagination, but again, the height of hypocrisy for me to complain about what 5 minutes means or doesn't mean. All right. The redhead QI said in the chat, he said, fucketh yeah. I think Alessi's probably pissed. He probably had a really good argument that he really wanted to make. I know. I'm not going to start down the road of fan fiction. I'm gonna try not to. Sometimes I can't help myself. Emily, you need to balance out your reading material. No, I don't. Bah. I will not be persuaded. All right, let's continue on.
All right, so I looked at the proposed supplemental questionnaire. They're very similar.
It sounds like we are moving on to the court talking about jury selection and the questionnaire with regard to jury selection.
So I have a question. So the Commonwealth on your number 5 on the first page. I don't like the 2 questions in a row, 4 and 5. I don't think we need 5. Is that okay with you, Mr. Brennan? I don't think we need both.
Needs to be done.
Yeah. So that's out.
All right, I'm going to see if I have any ability to gain the judge up a little bit because, damn.
So I'll go through, actually, I'd like to go through the first page of each. The first page of the defendants, number 13. Do you believe law enforcement officers are generally fair and accurate in their investigations? Who's arguing this for the defense?
They are going question by question on the jury questionnaire. It sounds to me like the process in Massachusetts is that you bring the jurors in, and this is some places they get sent them, sometimes they come in and have to do it. The jury pool gets pooled. We send out however many they send out. It's going to be 100 in this. I think I've seen a number of you say up to 200. You see how many people show up, and then they all get the questionnaires, and they all have to sit down and fill it out. So if you ever show up to jury duty, bring your own pen. Because you might have to sit down and fill shit in, but then they have to come in and fill out the questionnaires and go through them. So it's going to take time on the first day that they come in Massachusetts, they give the jurors questionnaires and then they have to go through them. So what they're doing now is refining what's on those questionnaires before the jury comes in, because each side can suggest or propose questions, different way to word questions, etc. What we saw happen in Murdaugh and in a lot of cases is then they will go through the questionnaires and pull out the jurors that just aren't a fit. And those jurors will just get yeeted immediately. They won't even seat them to ask questions, just yeet on the questionnaire before they even come in for the face-to-face voir dire. So let's continue. Oh, the court's real hard to hear.
All right, so I don't have a problem with that, but it makes sense that we put it after 8. Those series of questions.
No objection to that.
All right, any objection to question number 13 and putting it at 9, Mr. Brennan?
I don't have any objection to moving it after 9. I think it's a bit one-sided. It leans towards one-sided, but I don't have a strong objection to it.
Then why are you bringing it up?
If there's an invitation to balance, I'll need a moment.
All right, so
I'm just going to say Lally is sitting there like, can I go home yet? Are we done? Like, Lally looks miserable. Now, he might have his phone under the desk and be texting, and that might be the posture, but Lally looks miserable. Just absolutely miserable.
you can suggest something at some point. All right, so now moving on to the second page. The Commonwealth's number 17 seems appropriate to me, but if you were working for the same
He should be playing Midas Mage.
document that's not in the defense when it was removed, I guess. Is there anything about crash reconstruction testimony that would make it difficult for you to be fair and impartial in this case? I don't have a problem with that question. Does the defense?
We didn't have a real objection to it, it just wasn't a particularly useful question. We thought at the last trial, everyone said no, so in furtherance of trying to have additional space for more helpful questions, we just decided to exclude it.
All right, I
That's
think
fair.
we'll keep it. There's one I do want to get rid of that caused problems last time, but we'll talk about that.
Ooh, what caused problems?
All right, so thank you. So, question number 23 on the defense. Does the Commonwealth object to that question? I think it needs to be tweaked at the least. This little.
We do.
All right. So what's the objection?
I think the question, the way it's written, invites a juror to potentially not follow the judge's instruction. And so I understand the attempt, the idea of it, the germ of it, but...
We're
the
not
way
in
it's
real
written,
time, sadly, so Lally's not watching us. Or at least not,
the jury to-
I mean,
or
maybe,
juror
I
to
doubt he
discern
would be watching anything in court, but
And what do you say to Ms. Little?
merge games wins.
I think if we just tweak the language a bit, I mean, we're happy to hear some proposals from the DA as to sort of the particular issue they have with this question, but I do think the question about the judge's instruction regarding, you know, you're entitled to your own independent and individual verdicts.
So they're always told that their verdict must be their own. So there's language in there's probably language in my preliminary
Instructions.
There's
Yeah.
language in the charge, certainly. So if it mirrors that language, I don't have a problem with it. Otherwise, I might. So
We can mirror the
talk to each other
the
about
court's
that.
charge.
All right, so,
We would agree to that as well.
okay, thank you. Number 25 in defense. If you had to vote today on whether Ms. Reed is guilty or not guilty of the crime charged, what would your vote be? It's
Ew.
told throughout the trial, they know not to speculate, they were not to make up their minds until all the evidence is in.
I hate that question.
I'm not going to even suggest that this is appropriate. So I'm not going to include that. There are enough questions on reasonable doubt, presumption of innocence.
Yeah, I don't like that question. And the question was, if you had to vote right now, what would your vote be? It often is a trick question. And the trick being that any juror, before they're presented evidence, would have to vote not guilty. Sometimes defense attorneys will use this to be like, oh, the jury is in the mind of saying and having to say not guilty early on, but asking them how you vote today would have to be not guilty, but it can be confusing and it can cause issues. I don't like the question. I'm not surprised the court's like, get that out of here. It doesn't stop people from trying to ask it, because what I think some attorneys try to do is really solidify for the jurors, look, sitting here today, you have to vote not guilty. And a lot of people are like, but we wouldn't vote today. Like, that doesn't make sense in the way that the world works because we just walked in. And so they're trying to test the presumption. I think the fairer question is, you understand that Karen Reed is presumed innocent from the moment you walk in here today, agree, disagree, or whatever. I think there's other ways to test the presumption of innocence other than you have to vote right now. I don't like that question. I think that'll get yeeted. It's just problematic.
So that's out. So the question, also, is there any reason why you do or do not want to serve on this jury? I don't think we should invite them to decide whether they're innocent.
Asking a jury, is there any reason you do or do not want to serve on this jury, opens up the biggest fucking can of worms it will open up every excuse, every complaint, every, like, I am anxious. I don't want to sit for that long. I have work. Oh, that's a can of worms question. I wouldn't ask it either, Your Honor. That question, no, that's nope.
This jury or not. I think we did give this last time. I don't know what the responses were. Does anybody have any information on that for me?
No, that's a mess.
I think most of them were no. I think 27 kind of hits the same sort of, if you
Right,
have
if
general concerns about the case, so I don't have a strong objection to
If
that.
that's what would getting at, we've got it in 27. So I'm inclined not to put it on there. Again, I can hear from you beforehand, probably in writing, I don't want to bring you back.
I picked a lot of juries, so I have very strong opinions on jury selection, but it's personal to the attorney. When the court asks, and the court generally should ask, is there anything else I need to know or you need to let me know? That would generally be the time to say, my concern is, like, for me, one of my concerns would be, my concern is, like, overhead lighting, fluorescent lighting gives me migraines. So if this is going to be like a 3-week trial, I'm going to have my eyes closed midway through the day, because unless I have a hat, I can't sit here with the overhead lighting. I can't do that. That would be one of my concerns that I would bring up and say, can I wear a hat? Like, if I can wear a hat, I'm good. But if I can't wear a hat, this lighting's going to wreck me, and I'm not going to be able to pay attention to the evidence. That would be the same for, hey, my hearing isn't great. My concern is, what if I can't hear the witnesses? So that's generally the time that people will organically bring up any questions or concerns they have about serving on jury duty when the court says, is there anything else I need to know? But asking, is there a reason you do or do not want to serve on this jury? Just can of worms. And also, if jurors are like, no, I'm fascinated, I've always wanted to serve on a jury, they're probably also going to get kicked off. You have to assess other reasons. If somebody's trying to infiltrate the jury because they have strong feelings on the case, they're not going to answer you honestly anyway. So, but that's the time. So if you are ever on jury duty and you have a question or concern and the court says, is there anything else, any other questions or concerns? You can say yes and tell them. And if you don't want to tell them publicly, you can say it's a medical thing or it's private, and then they can take you to sidebar and have that conversation. So just for all of you in the future, if you're on jury duty, that's the question. A lot of judges will ask, is there anything else I haven't asked?
May I alert the court's attention, there's two on the first page that were slightly worded differently in the Commonwealth proposed questionnaire.
I can hear a little better.
If the court looks at number 4,
It's like the court's mic's not on.
On the defendant's questionnaire, we had kind of combined the Commonwealth's proposed questions 4 and 5.
Yeah.
So that's one question.
So that's, and I just got rid of Commonwealth 5.
Perfect.
So this one's better, so we will use that.
Okay, and then number 7 that was proposed by the defense, that is the similar question as number 8 in the Commonwealth's proposed questionnaire.
Yes.
It's just different language.
I thought it was the same.
So we changed it to say, would you tend to believe or disbelieve law enforcement officers, firefighters, or first responders more than a civilian witness simply because of their occupation, as opposed to automatically believe?
So we typically ask the automatically, what's the Commonwealth's position on this?
I have a strong preference, I'll defer to the court.
All right, so I will think about that.
What's the Commonwealth position? Meh.
Thank you, Your Honor.
Meh. What does the Commonwealth think? Whatevs.
All right, so the question that I don't like, and you may remember, causes a lot of jurors to say, I have no idea what you're talking about.
The court just said the question I don't like and causes a lot of problems, and now I'm very curious to see what the court found to cause a lot of problems. So tell me more, Your Honor. Tell me more.
21 on the Commonwealth's, 20 on the defense. So you may find the defendant guilty based on circumstantial evidence, but you cannot find the defendant guilty based on speculation, guesswork, or surmise. Is it difficult for you to understand the difference between circumstantial evidence, speculation, guesswork, and surmise?
Oh, that's a terrible question. That's why.
Can you repeat that?
It's your
That's exactly it. The court said before they read that question, the court said this question caused a lot of problems last time and people didn't understand it. And the court reads it all out and then looks at Miss Little and says, is there anything else? And she goes, can you repeat that? Exactly. It's a bad question. That's handled in jury instructions. And it's handled in jury instructions. Trying to explain circumstantial evidence to a jury before they've heard anything. This is why law school's so hard. In law school, you learn a whole bunch of stuff. and you don't really have any practical place to put it. And so it's like trying to learn a physical thing theoretically, and you're trying to theoretically, I don't know, figure out what it feels like to shoot a bow and arrow. Somebody can talk to you about it all day long, but until you try to do it yourself, it is something that is harder to envision. And so when you're looking at a question that talks about the difference between circumstantial evidence and speculation, and you don't have anything to check it against, it's really confusing. That is for jury instructions. That is for jury instructions. Jury instructions. That question is terrible.
Number 20. I'm not going to read it again.
Little's like, what? And the court's like, I'm not going to read it again. It's number 20. It's a bad question.
It caused a lot of trouble before. I think it's every single one I had to repeat myself with the instruction that I gave in anticipation of this. I gave them a pre-charge on circumstantial evidence and not being able.
Yes, just the way that it's phrased in the Commonwealth's questionnaire makes it seem that the Commonwealth doesn't have to meet their burden of proof.
I think it should be omitted completely.
I have no issue with that. It's just the way that it's phrased in the Commonwealth's
It's a
questionnaire.
bad question.
It's too confusing in my mind.
Okay, it took up, if you remember, it took up an inordinate amount of time, virtually every single juror.
We have no problem with that.
Yeet.
So that will be omitted.
Good. It's a terrible question. That's for jury instructions.
Yeah. Ms. McLaughlin, I think you said, and I think I cut you off the other day, that the third page was right from Chisholm. I reread Chisholm all 95 pages of it the other day, and I didn't see it. Where does this third page?
The court in this moment is just me. Miss McLaughlin, you said this was based on Chisholm. I reread all 95 pages of Chisholm. Just me. Just me. Every time I talk about a filing being 80 pages or more, I'm just like, oh, stop it. Literally say less. The court is just like, are you kidding me? Making me reread 95 pages of this ruling. The court is not pleased, but also the judge has so much reading to do ahead of this. So much reading to do ahead of this trial. I'm not surprised that the court is just like, stop it. And yes, chat, the case name is Chisholm. Yes, we've talked about taint teams today. I know. I'm with you. I'm not telling you you're wrong. I'm with you. But every time I point out the length of something to express either pleasure and or displeasure about it, it's hilarious to me that the court's also just like 95 pages. Really?
The questions come from Chisholm that were asked in the juror questionnaire. Some of the other cases, questions were part of the juror questionnaire in the prior trial that just moved over to this page. So this page dealt with a questionnaire exclusively on trial publicity.
Okay.
Page 3 is about the media.
I think that we all know many, if not most, and perhaps all potential jurors have heard about this case. Giving them the opportunity to write the details that they recall down may take an awful lot of time and space that
I think it's
we don't have
needed.
on this form, and frankly, I don't think we have. So,
I think they
what are
need
your
it.
positions on, what's your position on 3?
They're talking about page 3. Page 3 in the juror questionnaires is regarding media. What have you heard about this case? The court's right. The court said, I think almost every juror is going to have heard of this case. You're not going to find a jury that has not heard of this case. That's not even the goal. The goal here is to find jurors who have not made up their mind, who can be impartial, and who, even though they heard of the case, were like, I heard of the case because people are talking about it, but whatever. And the only way to do that is really to ask them what they know about the case. The court stated that her concern is, well, if we have people sit down and write everything they know about the case, that might take some time. But you need to know that. If a juror's like, let me give you a dissertation on this case, they probably know too much about the case. But also doing that one-to-one, maybe the court really wants to hear them explain it in person instead of having them write it all down. I'm interested to hear what the court's solution is for that. But yeah, you have to ask about media and how much people know about this case.
If I may, I can just hand up the excerpt from the Chisholm case that outlines the.
All right, I'm not sure 2 lines are enough space for it.
I don't think 2 lines are enough space either for what people have heard about it.
All right, I guess we'll see what we can do. I didn't realize it came directly, same language.
It's so funny because they leave YouTube out of everything. They're like, have you heard about this case on the radio?
Yes, Mr. Chairman.
And I mean, maybe some of you have heard me on Carson and Kennedy in the morning, but I think not calling out YouTube specifically is so funny. Have you heard about this on a podcast? YouTube is now the #1 platform that people listen to podcasts. It has beaten out Spotify and every other platform. YouTube is now the #1 place that people listen to their podcast. Not naming YouTube specifically is so wild to me. It's like, have you heard about this on the radio? Have you heard about this on, on a podcast? Have you heard about this in a magazine? Have you heard about this on television? It's so funny because people will be like, no, I haven't heard about it on a plane or on a train. I do not like green eggs and ham. I do not like them Sam I am. A lot of people would say, no, I didn't see this on TV. I didn't see this on a podcast. I didn't hear about this on the radio. I heard about it on YouTube. And YouTube might be local media, like your local NBC affiliate. It might be your local radio station that also broadcasts audio onto like a YouTube or Spotify. Anyway, I will stop ranting about the fact that it's silly to leave out YouTube specifically because people might not think of watching YouTube and watching TV the same way we do.
Your Honor, I want to bring to the court's attention something about the court and counsel just discussed question number 7. Can I ask the court to direct its attention to question?
Which page?
Sorry,
Current page or previous
the
page?
defendant's questionnaire on the first page. That was the question I think the court's going to consider whether to use the word automatic or tend to. I believe
He's like, can
that
we go
should
back
be
for a
broken
second?
into 2 questions. It doesn't tell us anything. For instance, the way it's written in the disjunctive, would you tend to believe or disbelieve law enforcement officers, firefighters, first responders, more than civilian witnesses, just simply because of their occupation? If someone says yes, we don't know if that's believe or tend to disbelieve. So I think if we just break it into 2 questions and now we've got the space to do it, that would be more instructive.
Why does it matter if it's an automatic belief?
I'm not worried about the automatic part. It's the believe or disbelieve. That's the part that doesn't help us.
Right, so if it's automatic, simply because of a person's occupation, this juror would automatically either believe or automatically disbelieve. How does it make that person a good juror? Why do you need it?
Because that tells us, it would instruct me at least, it would enlighten me on how to further question that juror. If someone says, well, I automatically disbelieve police officers, or I automatically believe police officers, those are 2 very different.
The court was saying if somebody automatically believes or disbelieves a witness based on their profession, they're probably not going to be a juror, so we don't need to even ask more questions because done. That's what the court's saying. Jackson's like, no, I want to know what the further questions are, and the court's like, I'm over it. If you automatically believe or disbelieve someone because of their job, you're out because there's no critical thinking there. It's like, I disbelieve all XYZ. Done. Just done. I think that's where the court's getting to.
Mindsets.
So I understand that. I'll consider it. I think we keep it as 1, and then if they say yes, we acquire it. Maybe. Let me see.
Okay. Thank you.
Right, if somebody says they automatically believe or disbelieve someone, they're going to get
either.
yeeted.
Page as well. I think. I have the statutory questions that I would ask of Yannetti.
Ugh. I realize it's a regional difference. I find certain things more irksome than others.
If we take that question
Venire is
that
one of
Mr.
them.
Jackson just talked about, I can ask each individual.
Put me in the category with people who hate the way a specific word sounds. There is, look, I don't know if this is an East Coast, West Coast battle, but all the jurisdictions I've worked in, veneer. It is pronounced veneer. Venire just, I hate it so much. Yes, chat, it gives me the ick. I hate it. I hate it. I hate it. I'm going to try to not mention it every time she says veneer, but good God.
Juror, if I use the tend language, if the testimony were in conflict, would you tend to believe the testimony of a police officer more than any other witness simply because he or she is a police officer? And then conversely, would you tend to disbelieve a police officer simply because he or she is a police officer? I typically do that at sidebar in every case asked exactly like that. So it makes more sense to me that we do it that way rather than a questionnaire. But if you want it on the questionnaire, it will stay as is. So what's your thoughts there?
That would be the defendant's preference.
Do you care, Mr. Byrne?
Just Jay, I think veneer is the proper way to say it, but again, when we're talking about different Latin words, it's hard to know, but I think veneer is the proper pronunciation. But it is a regional difference. Some jurisdictions, you see people saying venery, and I think it goes back to what is proper where they are. So that's where we're at.
We prefer a questionnaire.
All right, so I'll think about it, I'll do it one way or the other, and you'll know next week. So one of the things that I was considering doing, so we have a lot of jurors coming in next week. On Tuesday, 218 jurors.
Also, I had to double check for you, chat, because I didn't want to spell it wrong, and I don't do a great job with spelling dyslexic. Just, it is. It's V-E-N-I-R-E. It is pronounced by everyone that I know as veneer. I understand why the court pronounces it venery, but veneer. Also, the Latin translation of that is to come. So we're just going to leave it there. But we needed to go down the rabbit hole of veneer, but it means to come. It is literally the bringing in of the pool to select down the jurors. But just there it is.
Have been summoned, is my understanding. We will get some portion of that. We will get some fraction of that maybe, just on how it goes with whether people are here and available to testify on that date. To serve as jurors. So say we get like 150 or 175 jurors. I have my remarks to sort of just direct them to what their job is, as you remember, and then I leave and I give them the questionnaires. My guess is for the jurors to fill out this questionnaire, have the questionnaires collected and copied, might take an hour and a half or 2 hours.
Yeah, it's going to take some time.
Really large number of people. What I intend to do, at least on Tuesday, is have all the jurors fill out the questionnaire, however long that takes. And depending on how many jurors we have and what time it is, maybe take 50 of the last jurors or so, send them home, and have them come back the next day at 11 o'clock. If we've got fantastic court security here. Hopefully we've got a courtroom to keep people in. There are a lot of things we have to juggle to get this done, and I don't want to waste jurors' time. So I would send them home, have them come back the next day at like 11, so that then the next day's jurors at 11 o'clock can spend that hour and a half, 2-hour process, filling out the forms, having them copied, given to counsel, and we can continue on with those jurors. So it's something we can decide on Tuesday when we see how many people are here, how many jurors we get, how many jurors the district court needs. But is that a process that you would be willing to do?
It makes sense.
Of course. No objection.
All right, so
Yeah, it
we'll
makes
try
sense.
and figure out something that way to get things moving that way. All right. The list of witnesses, you both have a list of witnesses. I told you you needed to combine them so that I can read that to the jury and the statement of the case to the jury.
Did tell them to
Do you
combine
have
them.
that yet?
We have not combined them.
All right, so I need you to look at that, and a statement of the case to read to the jurors. It's all part of the final trial conference. So I should have had it last week. So I need that by Thursday. Is there anything else we need to discuss today?
There's still a few outstanding issues. One is ARPA. And
Where do you stand with discovery on that?
I received some TUI letters last night. It is not the information I was seeking from my motion that was allowed by the court. And so I have grave concerns about waiting for the day before they have to.
You have what now?
Pursue the other discovery that I think I'm entitled to.
What do you say, Mr. Jackson? James Jackson.
Your Honor, I do not know what.
Oh, at least Alessi's easy to hear. Brennan has grave concerns about the discovery that's been turned over with the ARCA witnesses. I'm interested to see what Alessi has to say about that.
What Mr. Brennan is referring to with regard to what he's looking for and grave concerns, the hyperbole is unnecessary.
So there was a motion allowed, so that should be able to, there was a motion for the discovery allowed a while back.
It
So
was.
that should narrow.
Right.
This level of hyperbole is unhelpful. Now we've gotten to this level of hyperbole is unhelpful.
Right?
Pardon me?
That should narrow things.
It does, and we have not, I attempted to confer this morning with Mr. Brennan, and my recommendation to the court would be for us to confer further, because I just don't understand what he thinks is out there, but we haven't conferred fully either.
Okay, all right, so do that, we can address this next week. I think we're going to have plenty of time to sort of tie up loose ends during the impanelment process, because I think it's going to take a very long time to get a jury.
I think the court's right on that.
Understood. And I expect we'll file a response to a proposed expert.
The Commonwealth of everything they have a right to be annoyed about. The discovery on the ARCA experts is something that they are frustrated with. I understand their frustration. However, in the scheme of everything that's gone on with discovery in this case, I just am not that flustered about it. It's just, okay. But it is hard for the Commonwealth without the discovery. However, those witnesses did testify at the last trial. This is a new trial. They should have the discovery, but it doesn't put them at the worst disadvantage in the world, and it doesn't put them at a disadvantage like the defense not having the videos that they should have. The defense should have access to all of those videos that were still getting turned over. So it's frustrating. Sure, it should be turned over, but what actually exists and what doesn't exist is part of the problem, which is why there's going to be another voir dire with regard to the ARCA experts. Yeah, it sucks, but you also know that that's one of the things you're going to have to wait for. So you're just going to have to wait. Is it annoying? Sure, but does it put you on the worst disadvantage ever? No, and the court's not going to keep those witnesses out. So you're going to have to kind of roll with it on that one. And at least the Commonwealth has the last trial to refer back to, even if they don't have all the discovery that they want. And Alessi's not wrong saying, I don't even know what they're looking for. To be fair to the Commonwealth's like, well, I don't know what we're looking for either, because we don't have the discovery, which is where the defense is with, like, do we have all the video? Because we can't say, no, we need this video. If you don't know it exists, you can't ask for it. It's a difficult loop to be stuck in.
We received a report last night, and I didn't receive it until later, which I want to have a chance to respond to.
And Your Honor, if I could, please, one more item when it's appropriate for Your Honor.
That's okay, go ahead.
Thank you. We did receive the, Your Honor may recall the argument over Dr. Welcher in Your Honor's direction, request, and then the assent of the Commonwealth that they would redo what they had provided, that 140-slide presentation. We did
Well, Your
receive
Honor,
that, but
while we're
we
talking about
received
discovery,
a lot of other
the
material
Commonwealth.
in addition to that, huge megabytes. I haven't even been able to open it up. It takes so long to open it up. I respectfully request that
Too many megabytes, Your Honor.
Your Honor grant us, please, 2 more days than what we had to take a look at that, because it's just taken an extraordinary amount of time.
Makes sense, Mr. Brennan?
I can be clear, there's no new information. What Mr. Welcher did is that all the information he based his opinions on was in the gigabytes we provided.
They're not saying that it's not provided. They're saying that you were supposed to narrow it down and you didn't narrow it down, so it's wasting their time trying to dig through all of it. And they're like, what the fuck? You were supposed to narrow this down and you've dumped on us and it's too much to dig through. That's what he's arguing about.
The defense, but he wanted to make it as seamless as possible, so to effectively hold their hand through it, he put each site under each slide so they can find it in the file folders exactly where it is. So it's instructive and helpful, but it's not new.
Your Honor, if I may, I don't disagree with Mr. Brennan's characterization. However, it is still 140 slides or so. I was expecting a rather substantial narrowing, so what we have to do is we have to go, and unfortunately, I think Your Honor is going to hear similar points that we made, but it's going to take more time, because I had the expectation, maybe unreasonably so, that it would be a narrowed slide presentation, so I'd appreciate the 2 extra days.
All right, so when does that put us at? What was the time frame originally?
I'm sorry, Your Honor, I don't have the specific date handy right now.
The time frame as far as the response?
Yes.
Well, we were supposed to exchange discovery yesterday. And so I had that presentation sent over last night. They sent over the 2 letters, and I received the third dog experts.
So end of the week, 2 more days.
If I could, Your Honor, I maybe Attorney Brennan misunderstood the question. He is correct that he provided us with the presentation last night, but the question, I believe, Your Honor, is when was our time? Because Your Honor had given us time to respond, and I apologize, I don't have that date, but what I'm just asking for is 2 more days, Your Honor, but...
I don't think I gave it to you.
Yeah. Okay.
So you have 2 days to respond to that.
I have 2 days from today.
Yes.
Okay.
Great. You want 2 more days? Here's your 2 more days. 2 more days from today.
So there are a few matters outstanding. I will have the decision on the motion to dismiss, should by the end of the day, buffer zone, probably by the end of the day. And I'll get everything else done as quickly as possible. All right, anything else?
The only other thing is the logistical issue as it pertains to both the voir dire process as well as during the trial. I wanted to ask the court if there was a mechanism by which Ms. Reed could have at counsel table some sort of an earpiece or headphones or something that's slaved to a microphone up at the bench at sidebar so that she can listen in on both. It's very
selection sidebars.
I want to avoid that if possible. It's clunky. Especially during the voir dire process. I think it would be uncomfortable and quite frankly.
What the court said, the defense is asking for a microphone up at sidebar with headphones so Karen Reed can hear what's going on at sidebar. And the court said, well, she can come up to sidebar. And the thing is, Karen Reed going up to sidebar, this courtroom is a odd layout for me, and it's small. So having the defense attorneys plus the prosecutors plus the court plus Karen Reed can be a very small area. So they're saying we want her to hear it, but we don't necessarily need her to come up to sidebar. But what the court said, and I could barely hear the court, what the court said was she can come to sidebar. Let's hear what he has to say about that.
I think it would be a little inappropriate to have jurors with Ms. Reed
Yeah, he's saying it would
right there
could be
with them
weird.
and with us.
It's done all the time. It's not
It may be done all the time, but
It may be something you're choosing.
It's done all the time is what the court
She has
said.
every right to be there at sidebar, so you don't want that, you want some accommodation.
That could be awkward though.
we could,
The defense's tech team could probably get that set up if they had access to power.
one of the things that we were talking about is potentially a closed circuit wireless microphone up at the bench and a set of headphones here that she could listen in on.
Put it all in writing. I
Okay.
would like to have had it before today. We've been moving around courtrooms. It may not be able to happen.
Okay.
All right, so the alternative is she can come to sidebar.
I mean, if the defense can figure it out.
sidebar discussion,
I don't know why it
handle
couldn't
it,
happen.
Whatever, it's her absolute right. If she chooses not to do so, I'm going to need you to tell me that.
I'll put something in writing, and perhaps, I've got the plan in the back of my head, I'll put it in writing.
We have a lot of different equipment that we need to make sure has priority. It's a
Understood.
courthouse, so I'm not very hopeful that we can accomplish this in the next few days.
Okay, well, thank you for entertaining.
The defense would have to come up with a fix.
One thing, when we get the juror questionnaires, the supplemental juror questionnaires that we talked about, and I need you both know what my decision is here, other than the 10-2 versus automatic. Let's go with 10-2. And I can either do that in sidebar or in the form. What I'd like you to consider, and lawyers have done this in other cases that I have, is if there are answers that are clearly what you believe would both sides agree jurors excused for cause. In an effort to be able to go through this vast amount of jurors that the jury commissioner's office was kind enough to summons in for us, if things stand out to you, it would be ideal if you could agree that jurors number 8, 12, and 16,
that makes
both sides
sense.
agree should be excused for cause based on the supplemental questionnaires. It would be very helpful if we could do that.
That makes sense.
And maybe keep a running sheet that would be a joint proposal to excuse these jurors for cause. It may happen when you look through the questionnaires, folks that we sent home to have them come back the next day, to just call 5 people.
Yeah, call them if they've already been
Just
kicked.
call them and tell them not to come in.
That makes
based on
sense.
the questionnaire. So please think about that. It makes sense to me.
That is
It
logical
was very
to
helpful
me.
when lawyers were able to get along well enough to do that in a case that we tried, that we had changed that.
Your Honor, you have been sitting in this courtroom with these attorneys since Brennan came onto the case. It's been very helpful when lawyers were able to get along well enough to do that. Okay, hopefully they will, but it's very helpful when the lawyers can go through the questionnaires and be like, these jurors, we agree to kick for cause, and then you just kick all those numbers out. That makes sense.
All right, anything else?
No, thank you.
Your Honor, there was a motion for reconsideration that was filed with regard to the metadata underlying, I can.
You can make an objection. Go ahead.
I just wanted to make sure that the court saw that motion and that it was filed. I don't know if the court wants to hear a full argument, I'm happy to do that, but we just wanted to make sure that that gets decided.
Okay. All right, there's still a few ones.
Thank you.
All right, anything else?
Not from this, Your
All
Honor.
right, we'll see you on Tuesday.
All right.
Please.
We are done with court for this day, law nerds. So, as they wrap up, we came to, well, surprisingly, decisions today. There were decisions that were made, which is surprising to me. So, before we go take a look real quick at the orders that the judge put out yesterday, which I am not going to do a deep dive on, because traveling and I have things I have to go do. But I will probably dive into that more for the Emily show or next week. But at the end of court today, the thing that surprised me the most is that the judge here, let me pull the microphone closer for this one. Let me just bring it in. At the end of court today, the thing that surprised me the most in this Karen Reed hearing is that when the judge cut off the defense as they were arguing about Karen Reed's text messages or other communications with her attorney, David Yannetti, that were on her cell phone, that the court cut the defense off in the middle of their argument and then said, I'm denying this motion. I'm not giving that to you, Mr. Brennan. I was so surprised that that was the court's decision to not only rule from the bench, but cut the defense off in the middle of their argument to rule from the bench and to deny the motion where the Commonwealth was seeking access to those records. I think one of the most persuasive things for me in that, because the court said, I understand what you said about waiver, but I don't know if that means the Commonwealth gets those documents. But the Commonwealth asking the court to dig through redacted information, attorney-client information, and ask the court to decide what gets turned over is a mess. It's a mess. It's a mess of what they're asking the court to do. And so, well, I'm surprised the court ruled from the bench and didn't let the defense finish their argument to rule from the bench. I'm not surprised at the end of the day by the court's ruling here and saying, I'm not turning those overs. I'm not turning those over. And that doesn't forestall the Commonwealth from seeking to bring in the content of that conversation through Karen Reed's interviews, not from text messages, but Karen Reed said, this was the conversation I had. That might be able to come in down the road through Karen Reed's own statements, but they are not getting the information from Karen Reed's phone. I'm still surprised that the Commonwealth asked the court to dig through that and didn't say, either we need the taint team to do it, we need another judge to do it. This judge wasn't going to do that and very much made that ruling clear. We also know that the court granted a buffer zone similar to the way that the buffer zone was granted last trial, that nobody can use audio enhancing devices, so like bullhorns and things like that. Nobody can wear clothing. It doesn't say anything about signs specifically, but nobody can wear clothing, talking about one side or the other, and that the buffer zone needs to be 200 feet, and then they extended some of the roads around the courthouse for that buffer zone. And the court made clear that law enforcement, when they come in to testify, cannot be wearing not microphones, can't be wearing their uniform or badges or anything like that. But they did the 200 feet, but then they also did some other roads that are encompassed. So with all of that, there will be a buffer zone. Again, there will be a crackdown on audio amplification, bullhorns, things like that. No clothing, those types of things. So when I see you guys asking in the chat, so they can't wear pink, I think you could wear a color. I don't think it can say anything about one side or the other. So that's what happened in the ruling with regard to the buffer zone. Right now, we are going to take a look at the denial of the motion to dismiss, and really that's all from court today. They worked on the scheduling of the trial. The trial is going to start April 1st with jury selection. The court has said repeatedly, I think jury selection is going to take a significant amount of time, and I think the court is right about that. Trial testimony probably won't start until the end of April, so we are going to have about, it looks like maybe 25 to 28 days where the court will be in jury selection. Jury selection is not televised or streamed, but there may be hearings and evidentiary hearings that go on in that time. If they do, I will stream them. You're going to have the Law Nerd app as we get into trial season, because sometimes those are unexpected, and so we can't always plan for them. And I can let you know in the Law Nerd app if we're going to go live unexpectedly or shift around the time of a live to accommodate trial. Oftentimes that has been bumping things a little bit earlier than my normal streaming time to accommodate the court on East Coast time, even though I am in Central time and a lot of you are in different time zones around the world. Law Nerd app is free. LawNerdApp.com will get you there, and that's how you can stay in the loop and not miss anything that's going on during this trial. I think evidence will start either the 25th or the 28th, and that will be interesting to see how long it takes. It's going to line right up. It's going to line right up with the Corey Richins case, and we're going to have to figure that out. Natalie in the chat asked, do I think the defense will request a larger courtroom? No. Last trial, the defense requested this courtroom over the larger courtroom because the jury box and the witness box were so oddly situated. So this is the courtroom that they wanted. So we are going to be getting into jury selection in this case starting in the beginning of April. Let's take a look at that motion to dismiss. Let me pull it up real quick and put it on my other screen and take a look at it. Hold on. Travel streaming is always dynamic. And yes, to answer your question, Miguelina, let me grab a little water and then we will be done for the day. But let's take a look at this motion real quick. All right, let's see if we can begin. said motion just a little. Come on. Nope. There we go. And biggened a little bit. This is from yesterday. This is the court's, let's take off the live court because we're not in live court anymore. This is the court's order from yesterday afternoon, March 25th, on the motion to dismiss. As I said earlier in stream, I really thought that there was need for a evidentiary hearing on this, especially when we had to deal, well, with the strangeness of the video. So it's odd to me. We're going to look again briefly at this. The denial of the evidentiary hearing is what I'm going to, because that's really what I want to see why the court did that. It's just, yes, we're going straight Aquaphor this afternoon. I don't know why my camera's blurring, but straight up Aquaphor because travel makes me dry, always. This is the court's memorandum of decision and order on defendant's motion to dismiss for extraordinary governmental misconduct. The court says on June 9th, a Norfolk County grand jury indicted Karen Reed on charges of murder in the second degree, manslaughter while operating under the influence of alcohol and leaving the scene of a personal injury, and death following the death of her boyfriend, John O'Keefe, on January 29th, 2022. The Commonwealth's theory of the case is that the defendant, while intoxicated, struck and killed John O'Keefe while operating her vehicle in reverse and left the scene. Trial on this matter began in April 2024, concluded July 1st, 2024. That's right. If we are in this trial through July, well, it's DCI summer. I don't have time to be in trial through July. No one wants this trial to go through July. It was like, there is Dave there, like it's music season. No one wants this trial to go through July. It was so bad. And then Koberger starts at the end of August. This matter is set for retrial April 2025. Ahead of the retrial, the defendant has filed a motion to dismiss for extraordinary government misconduct. Such a drastic sanction is justified only in response to the most egregious and truly harmful conduct. But don't we need to know what happened with the video to know? In all but the worst cases, the appropriate remedy is at best a new trial, which is what I've been saying since the beginning. Most of the time, the remedy is a new trial, and that's where we're at. Poor Marine asked DCI is Drum Corps International. Yes. Band. Competitive band. Elite competitive band. And I've been saying that for the beginning, that a new trial being the remedy means a lot of this stuff is not going to dismiss the case, but I think they needed an evidentiary hearing to determine how bad the conduct was, because we just don't know. It goes on to say, because all the claim violations here do not rise to the level that would justify the most draconian sanction of dismissal, and because the defendant's constitutional rights can be fully protected in the coming trial, her motion to dismiss is denied. So I love seeing all the DCIs in the chat. Blue Devils are good. Blue Devils are so good. Wit said, I marched Blue Devils 2011 to 2025. Wait, 2015? That's a very... Wit's a vampire otherwise, because Wit's like, I never age out. I never age out. It was so funny watching DCI finals last year and looking at DCI finals last year with, the blue groups up there at the top, as always. So my cousin was a Boston Crusader. That's fantastic. I love seeing all of you in the chat talking about DCI. So we will talk more about it. But for those of you asking, and I see RK asking in the chat, this is going to proffer questions that I am not going to answer because I do not have permission of said child. But yes, my oldest will be marching DCI this summer. All of you are going to ask me with which group. He has not told me that I can share that publicly, but we will talk about it more down the road. So Trav is fairly private, and I respect that for him. But yes, my kiddo will be marching DCI this summer. Tony Carolina Crown is so good. I like their style so much. So yes, if you guys are at DCI this summer, keep an eye for my fax hat and purple hair. You might see me. All right, let's continue on with am going to specifically zoom because we're doing an overview. I'm going to specifically zoom because I want to see about the denial of the evidentiary hearing. And then this is, Your Honor, how many pages is this ruling? Like 30 something. But I will read it, and I have not had time to yet. I will read it and we will go through it more. Let's see. I see some Santa Clara Vanguard love in the chat. We see you guys are, look, this community is fantastic. Everybody knows. Everybody's like, banned. Banned. Look, I'm living my best band mom life. These trials are going to make me upgrade my streaming setup on the road because but yes, the international crew who's like, what is this? This is a competitive marching band. You can find the names that we're talking about are corps that compete in the summer, but it is competitive marching band, and they do very, very elite, dramatic, entertaining band shows with the drum and bugle corps. Lots of drum, lots of brass, lots of color guard, lots of fun, big shows, so great. Danny Dark Emo said I marched with Regiment. Phantom Regiment! I'm getting better at that. But that's the only way you're allowed to say Phantom Regiment. You have to yell. And then they have finals every year in Indianapolis. Anyway, living my best band mom life. Could not be more thrilled. I loved band when I was in band. No shade to, all the moms who love what their kids do. I would have not been as delighted sitting on a soccer field as I am to get to go to DCI competitions. Whatever my kids wanted to do was fine. This just delights me a bit more. So I'm so excited. All right. So this trial needs to not go into July. That was my rant. That's how we got here. All right. Let's see. We're not going to go. I'm interested in the. Oh, wait. Oh. The court put this. This isn't redacted? This was redacted everywhere else. Okay, we're looking at this because the court is spilling the tea. I just wanted to see about the evidentiary hearing, but if the court's going to put in shit that's not redacted, let us go ahead. Chrissy in the chat said, makes me think of American Pie. I have to shut it out from my mind. This one time at DCI, I have to keep the stories from my friends that marched DCI when I was growing up out of my mind. I have to keep it out of my mind. Because my child in my brain is a child, not a 17-year-old. All right, Massachusetts State Police interference with the jury factual background. During trial, 2 issues arose with jurors. The first occurred on June 14th when one juror, Juror A, reported to the court that another juror, Juror B, had made some comments about the evidence and the defendant, footnote 9. Let's go to footnote 9 literally immediately because T. Not T. The court has omitted identifying information. That's fine. Such information is not necessary. Also fine. This has been done to afford citizens who serve as jurors in this case privacy. Oh, that's fine. I don't care if they're jurors A and B. Just tell me who snitched, and who's talking. A juror got removed from the Cardi B defamation case because they were talking about, like, can you believe this person, the defendant in that case, said all of this stuff? And it was like, you can't talk about the case yet. Let's see. The court called Juror B to sidebar and questioned her about what she had said and if she could keep an open mind and consider the evidence in a fair and impartial manner. Despite her representations that she could, the defense expressed concerns that the comments had been one-sided and against the defense and asked that Juror B be excluded. The court then inquired of Juror A. Juror A stated that Juror B had made comments to her about the defendant's facial expressions during trial. And if you guys are going to ask, does this happen on juries? Yes. The facial expressions of the parties, the clothing of the parties, how tired the parties look, all of this jurors examine and judge. And sometimes judge wrongly, sometimes judge unfairly. I think what jurors forget is that life happens during trial, and there's no way to remind them that lawyers can have difficult things happening during trial. So if a lawyer comes in looking exhausted, it might be that shit's going sideways in their case. It might be that their kid is sick. It might be that they have an in-law that they're taking care of that's sick. It might be that, who knows? But jurors tend to attribute everything to trial. All right, so the defense wanted the juror yeeted and the court yeeted the juror, it sounds like. The Juror A stated that Juror B had made comments to her about the defendant's facial expressions during trial. The court then questioned two other jurors whom Juror A said were sitting close by when Juror B made the comments. Both jurors stated that they had not heard what Juror B said directly, but that Juror A had mentioned it to them. That's where Juror A's like, this is weird. The court then called back Juror B, who denied making any negative comments about the defendant. Your Honor, they weren't negative. I was just commenting on her face. After questioning the jurors, the court consulted with counsel. The Commonwealth expressed that if the court struck Juror B, it should also strike Juror A. The defense disagreed as to Juror A. The court ultimately decided to dismiss just Juror B from the jury. So the defense won that argument when the prosecution's like, get rid of them both. And the defense is like, no, that juror is bad for us. That juror is good for us. Keep the one that's good for us. And the court did it. The court agreed. That's new information. That the court struck the juror that was commenting on Karen Reed's face and kept the other one. On June 25th, just before closing arguments were scheduled to take place, the court received information from court security about another issue involving Juror A. Oh. Same juror. This was the second strike with this juror. That's interesting. That's interesting. The court received information from security about another issue involving Juror A. A member of the Massachusetts State Police had contacted court security. Well, we heard about that part. And said that he received information that a juror thought to be Juror A was at one of the local posts for the American Legion talking about the case, and that there may be a recording of her doing so. What? It's giving Murdaugh. It's giving Murdaugh. It's giving Murdaugh. At roll call for the Dedham police on the morning of June 25th, a number of officers confirmed that they had heard similar things about the juror. So who's at the American Legion? Like, everybody's just sitting around at the American Legion having drinks, hearing this person talk, thinking they're a juror. There were probably police officers there that heard this, or family members. That's me speculating. But that's wild. Let's see. At roll call, numerous officers confirmed that they heard similar things about the juror. The court called a sidebar to discuss this new information with the attorneys. Defense counsel asked for the name of the Massachusetts State Police officer who received the information. A court officer stated it was Lieutenant Fanning. Fanning is a supervisor of the Norfolk County Detective Unit. During the investigation of John O'Keefe's death, he was Proctor's supervisor. He was also one of the recipients of a group text circulated by Proctor that include reference to looking for quote unquote nudes on the defendant's cell phone, as well as a reference to counsel's, oh, we didn't redact that. Yeah, as well as referring to Karen Reed in a very unflattering way. Defense counsel represents, and for purposes of this motion, the court accepts that Fanning also interviewed some witnesses in this case. Fanning was not himself a witness in the trial. After explaining the attorney's situation, the court called Juror A to sidebar. The following exchange occurred. Oh, wait, I don't know if I have where do I have my chimes?
Bring the jury.
Nope, that's not it.
The FBI!
Damn it, that's not it either. Hold on. Shit, do I have them anywhere? Oh, there they are. I'm on the travel soundboard. We didn't know any of this because it was redacted last time. So bring me the tea. The court. It's been brought to my attention that you might have been out recently at an American Legion or Knights of Columbus or someplace like that in Dedham, and that someone has reported that you may have been recorded talking about the case. That's the information I received. What can you tell me about any of that? Well, that's a lot of information. Why not just ask the juror, have you been talking about the case? This is wild. The juror, I don't know. Can you tell me about that? IDK. Okay. Boy. Oh boy. I wonder what tone that was set in. The court, have you been at an American Legion Hall? The juror, like a month ago. Okay, at the time, were you talking about, not that I remember, no. Do you remember if people there mentioned to you anything about this case? I was drinking, I don't remember. I bet the drinks are less expensive. Is anyone shocked? I was there drinking. I don't remember. This juror does not sound pleased with the court. Damn it, am I almost out of water? Not that I remember, no. Do you remember if people there mentioned to you anything about this case? I was drinking, I don't remember. Okay. The further information I have is that this morning, several Dedham police officers said that they heard the same thing. What? Okay, but can you tell me why Dedham police was talking about you? Who could answer that question? I heard from Massachusetts State Police. Wait, no. I heard from the court officer who heard from Massachusetts State Police, who heard from Dedham Police that you were talking about the case. What? What can you tell me about that? Why did other officers hear the same thing? This is unbelievable. The court. Okay, the further information I have is that this morning, several Dedham police officers said they heard the same thing. The juror. Okay. Ooh. The court. All right. Could it have happened? The juror. I don't know. The court. Okay. The juror. I really don't know. The tone of this would be really important. The tone of the juror talking to the court would be really important here. Yikes. The court asked the juror to step aside and then discuss the matter with the attorneys. The Commonwealth expressed concern that the juror had been involved in a previous issue and requested the juror be excused. I'm not surprised by that. The defense objected, arguing that the previous incident was unrelated. Focusing on the incident, the court conveyed a concern that the juror did not deny the incident, but instead stated that she had been drinking. That's fair. The juror didn't say, I haven't talked about this case. I probably would have kicked this juror too. The defense responded that the court should consider that no other juror had been affected and that the source of the information was Massachusetts State Police officer. Thereafter, a discussion about Lieutenant Fanning ensued, with defense counsel suggesting that Fanning and the Massachusetts State Police may be targeting potential jurors for the purpose of trying to get them excluded from the jury. But the juror didn't say, I wasn't talking about the case. Not once in the exchange. And if the juror's tone is, okay, then it's different. Because the juror didn't seem surprised that law enforcement was talking about whether or not this juror was talking about the case. Yeah, I think based on that sidebar, I think I would have done the same thing, honestly. And I think if I was the Commonwealth, I would have asked for the same thing. I think if I was the defense, I would have asked for what the defense is asking for too. Like, I agree with where everybody's at on this. But that sidebar is weird. Yeah. Defense had concerns. Now we get to hear what ADA McLaughlin said. Oh, the court put everything. Is this the redacted version? Because we're getting a lot more information than we got before. Okay. Kat in the chat said they did, though. The first answer was no. Hold on. The first answer was no to have you been to the American Legion. Here's the problem with the first question. The first question is super compound. And the court said, what can you tell me about any of that? And the juror said, I don't know. Have you been to the American Legion Hall like a month ago? I don't think the court believes the juror. And then at the time, were you at all talking about, not that I remember? So, no, these answers are not good. Do you remember if people there mentioned to you anything about the case? I was drinking, I don't remember. It's evasive. It's evasive answering. Because what can you tell me about it with the I don't know? All right, ADA McLaughlin then explained to the court and to the defense counsel Lieutenant Fanning's role, saying, Lieutenant Fanning is the commander of the extensive security operations that this case has required. What occurred is he received the information. He did not investigate. He had no evidence of any crime. I don't think anyone thinks a crime had committed. If he did investigate or reached out to anyone, that could have been considered an improper influence on the jury. Okay, well, at least I recognize it. Let's see. What he did was report it to the chief of trial court security to make the trial court aware that this is simply a trial court issue. Sorry, my nose is itchy. Let's see. The Commonwealth then made its argument regarding why the court should dismiss Juror A. The court then conveyed its decision. I believe there's credible evidence that the juror has had conversation about the case. She did not deny it. I find that there has been a violation of the court order for failure to report it on a repeated basis with regard to Juror A. Repeated? I find that there had been a violation of the court order for failure to report it on a repeated basis. Juror A had no problem reporting the other juror, but then at the time also did not tell us that she had spoke to 2 other jurors I inquired of. Interesting. She told us that they may have overheard, and then it was another juror identified by seat number who ultimately told us that this juror had reported to her what the other juror had said. Okay. Excuse me. So the court is crediting Juror A, diming out Juror B, but then not saying, and I had conversations with jurors, C and D, which is interesting. And that's what the court is crediting here. That Juror B made a comment about the defendant's face to Juror A. Juror A reported it, but then Juror A also told others and didn't say, and I told other jurors. I get where the court's at on that. Because talking to other jurors about the case is talking to other jurors about the case. Even when, I gotta get myself some more water, even when the talking to other jurors about the case is, this juror was commenting on the defendant's face. Okay. Hopefully this is not too loud in the microphone. Sorry if it is. All right. If you're a juror, you should remember if you're speaking about the case, unless you're doing it a lot, which is also a concern. The court said Juror A may not remember whether she spoke about this case, but I wouldn't be surprised if she remained a juror if we did hear from somebody who was at the VFW that night after all of this. So for those reasons, I'm going to excuse her from sitting on this jury. I get it. I get where the court's at. I get where the court's at on this. You're trying to protect the case on all sides. And I think if there hadn't been the prior incident, the subsequent reporting wouldn't have been as much of a thing. I think the 2 issues with the 1 juror becomes more of a thing. Let's see. At this point, the sidebar conversation continued about Lieutenant Fanning. The following exchange occurred. AD McLaughlin, What I said was that Lieutenant Fanning is the unit commander of the security operations, which I know from the personnel the past 3.5 months, that's his role. Attorney Little said for the jury. The court said, hold on. ADA McLaughlin said not for the jury, for trial support and security. Okay. Defendant's argument is that Fanning shouldn't have been involved. We saw that in the moving papers. That's new information about the jury. And let's see, I'm going to go to what the court said. The court didn't say anything about why wasn't it a call out? Why wasn't it a call out about the evidentiary hearing? I wonder if it's a separate filing, because she denied the evidentiary hearing. I thought it was in here. It's not. Buzzcat in the chat said, but she's taking Fanning's word for it. I am not crediting the court with taking Fanning's word for it beyond inquiring. I think the jurors' answers in the previous issue were the problem, based on what I'm seeing. But again, the court's writing this, so we're getting it from the court's perspective. So, and I think the court needed to inquire of it, because jurors talking about the case is a huge problem, and it violates court orders, and judges get way more upset about violating court orders than just about anything else. Let's see. She finds that Fanning's not in charge of the jury. I don't know if there's anything in here about an evidentiary hearing. I wonder if it's a different ruling. I will look for it, chat. At the end of the day, here, let's get to the end. At the end of the day, the court denied this motion. I want to see what there's no conclusion? No, I guess not. It looks like the court's wrapping up each section in and of themselves. The court says the defendant also fails to cite any authority suggesting, as she contends, that the court was required to engage in an evidentiary hearing with Lieutenant Fanning before deciding whether to dismiss the juror. The court here called Juror A. Well, this will answer the question about what the court is thinking. The court here called Juror A to sidebar and to conduct an individual voir dire, heard argument from both defense counsel and the prosecution, and explained to counsel that the juror would be dismissed based on credible evidence that the juror had conversations about the case. The defendant was afforded all the procedural protections that she was entitled to before the court made its discretionary decision. Judge inquired of and then citing case law. For the foregoing reasons, the defendant's motion to dismiss for extraordinary government misconduct is denied. The defendant's alternate request for an evidentiary hearing is denied. Maybe she didn't talk about it at all. That's odd. Give me 1 second. I'm going to try to find the conclusion paragraph from the defense's other argument. The way that the court broke this up, is just a little harder to zoom through, but I'm wondering what she says about the video, because now I'm curious. The court says, in talking about the remedy for discovery violations, as noted repeatedly herein, the defendant has not demonstrated that she suffered any actual prejudice based on the Commonwealth's late discovery or failure to disclose evidence before the first trial. We talked about it. We talked about it being a difficult standard. We'll go through the rest of this in quick bits because there's going to be more to this, but I'm trying to jump to the court's breakdown. The court goes on to say, however, even if the defendant were able to show prejudice, the arguendo, the appropriate remedy would not be a dismissal of the charges. Quote, dismissal with prejudice is a remedy of last resort. Under the circumstances of this case, where there was a mistrial and the defendant now has the evidence at issue prior to the second trial, she cannot show that she suffered irremediable harm. It's odd to me that they use irremediable, not irreparable, but whatever, irremediable harm to her opportunity to obtain a fair trial under Commonwealth versus Dilworth, which says, quote, sanctions must be remedial rather than punitive in nature, aimed at curing any prejudice caused by the violation of a discovery obligation and ensuring a fair trial. The court says, indeed, even in cases where the withholding of evidence is brought to light after a conviction, the remedy is most often a new trial, not a dismissal of the charges. That's true. It goes on to say, nor has the defendant shown that the Commonwealth's conduct was so egregious, deliberate, and intentional that prejudice should be presumed. That's why I think there should have been a hearing. Because where the fuck was the video? Like, where did it go? Where did it go? How is that not deliberate? And again, I strongly think that there should be an evidentiary hearing because on the information the defense has, I don't know if they can meet, I think they've shown it was deliberate. I don't know if they can meet some of the other standards without more information, which is why there should have been an evidentiary hearing. The court says such a theory should be narrowly applied and confined to situations where the misconduct has cast such doubt as to poison the entire investigation. I'm sorry, Your Honor, are you quoting case law that seems to be on point? Because that case law seems to be on point. The case law says, should be narrowly applied and confined to situations where the misconduct has cast such doubt as to poison the entire investigation, and a stronger deterrent is warranted to prevent repetition of such misconduct. I guess we see things differently. The facts before the court do not depict a concerted and intentional attempt by the prosecution team to deprive the defendant of discovery which would have aided in her case. Law enforcement is part of the prosecution team. So even if it wasn't the prosecutors, okay, even if the defendant were able to show that the conduct at issue here on the part of members of the prosecution team was intentional, that would be law enforcement, the remedy would be a new trial and a timely disclosure of the evidence, not dismissal. Quoting case law, quote, whether an indictment should be dismissed upon the defendant's motion where the prosecution has acted improperly, thus turns primarily on the ability of the defendant to obtain a fair trial after and in light of the impropriety. In this case, defendant's rights to the disclosure of evidence pursuant to Brady and the rules of criminal procedure are fully protected because no verdict was returned at the conclusion of the first trial and the retrial is about to start. She has suffered no irremediable loss of any constitutional right, and her motion to dismiss on those grounds must be denied. So they're saying, the court is saying, which, again, I was hoping there would be an evidentiary hearing so that we would learn more, but I thought ultimately where we were going to end up is the retrial is the remedy. And where we're at is the retrial is the remedy. That's where we're at. The retrial is the remedy. I still think there's a lot of information unknown about what the fuck happened with those videos, and I'd really like to see it. But we're not going to on that. So I will go through this more for the podcast. Do not worry. We will cover it more for the Emily show, but I do not have time to cover it line by line today. I know you guys understand. Thank you. You were always very patient with travel, Emily. We're going to answer a few questions, and then we are going to bounce. All right, law nerds, I'm glad to get to cover this even when trial, because even when trial, even when travel, thank you to everyone who gifted memberships. B2 has gifted all of the memberships. Susan Jane, thank you for gifting memberships. I know so many of you gifted memberships to each other and celebrated your member milestones. Shanique Floyd, it's good to see you. Member for 25 months. Can't wait for EDB to start doing the stuff and the things. The stuff and the things. We struggled with the internet early on to get ready, but it seemed to knock on all the things. It seemed to hang in pretty well for this stream, even though we were fighting a bit with the audio in court. Look, travel streams are travel streams. They are just all of the things. Matt Bond, good to see you. Matt Bond said, hello, spiffy legal mumbo jumbo talkie, sister from another mister. I recorded Cartman doing the hear ye's. Thank you. Love my inner Cartman. Hear ye, hear ye. My Cartman's not good. And it normally goes, I do what I want. I do what I want. Marie G said, can we do a show on the housewives? So much going on. We've got to talk Teresa Giudice at some point. Y'all, how... We have got to talk about it at some point. Emily Ippolito said, if it's the Starbucks Reserve, they also do great coffee-themed cocktails. I have no idea what the noises are that are happening. I know there is a roastery near me, but there are also reserves, like, because New York has all the things except Akura, which we'll talk about another day. Like, why do I have to take a bridge to across somewhere to find a... It is what it is. I'm sure New York has much better sushi than Kura, but Kura is my favorite and I love it. But I'll go look for this. That I didn't know. Also, Fendi in the West Village traditional home. No, Ferdy. Emily, your brain went to brands in the West Village traditional home style Italian and cappuccino martinis. Oh my God. Thank you so much, Emily. That sounds amazing. I think a lot of you are over Brennan. I get it. Chris said, I had a hard time listening to Brennan's arguments since he's been so consistently shady during them. Yeah, he's burned a lot of credibility with me in the way he's misrepresented things, and his argument style as a prosecutor, I cannot give a lot of grace to because it is at times evasive, and it's not, I can't get over it. I do not like it. I do not like it. So I don't. So Lyndon, thank you so much. Lyndon said, love that EDB took the time out of her, in her travels to check in with us. Oh, you guys, it was gonna be a little bit of time off, and then the court bumped this hearing, and I was like, well, we're gonna have to talk about it. So we're gonna talk about it. We're not gonna wait. I can't even wait. I can't wait. I want to know, you want to know, we want to know. So we're making time to do it, which is perfect. That's so Lacey, said Emily. I was on a jury on a 2-day trial. Charges of first-degree physical assault against an elderly person. I was the foreperson. The whole process was amazing. That's so Lacey. I bet you have an entirely different perspective on these cases and insight. And yes, a lot of trials only take a couple of days. I know not the ones we end up watching, but a lot of trials only take a couple of days. When the evidence is strong, it's like this witness, this witness, this witness, this witness, done. It's just done. So done. Let's see. Amanda Scott asked a great question. Was Proctor being paid up to him being fired? No. At the end of the last trial, he was suspended and then really close in time thereafter suspended without pay. So no, his suspension without pay happened last summer. So he has not been paid while this hearing was happening. So nope. Hopefully that helps answer the question. So let's see, I'm going to try to pull up questions I can answer. It's nice to see all of your comments, because a lot of you have been listening to this trial and have a lot of really astute observations, and I'm seeing those in the chats as well. Truly Law says, on a plane, and I will not be raw dogging this flight. Need a vodka cranberry to avoid the headache of Brennan's argument. I don't know, man. This might be the one trial where grabbing a whiskey is not going to help, because the drinking involved has made everything so difficult. Just so difficult. Just absolutely wild. Let's see. K Skills says it was his 18th birthday. I thought it was the brother. It wasn't Colin Albert's birthday. It was the other birthday. It wasn't Colin Albert's birthday that they were celebrating. Colin Albert is the cousin, but if I'm getting that correct, the person at 34 Fairview who was having the birthday was the other Albert. Yes, chat's saying Brian Albert Jr., that's what I thought. So they're cousins, but Colin Albert came over because Brian Albert was celebrating his birthday, Brian Albert Jr. Thank you, chat. I couldn't remember. Here's my impression of the other Albert whose birthday it was. I'm like, oh, I'm so sorry the adults fucked up your birthday. Like the adults just ruined everything. Brian Albert Jr. was like, I just want to be chill. I just want to have a few friends over. I just want to be chill. And then the adults were like, we're going to keep drinking. We're going to keep drinking. And the testimony from Brian Albert was giving exhaustion with all of it. Just exhaustion. But I also wonder how often that happens at his house, where all the adults and the aunts and the uncles and the friends all come back and drink at the house, and whether or not he was truly just over all of it. He was like, I just wanted to hang out with a few of my friends. Can you all miss me? And they're like, no, cheers. We're not going to at all. Rebecca May Stone said, I just realized it's my 2-year long-honored anniversary or birthday. Congratulations and welcome and thank you. Wait, hold on. I misclicked, Miguelina, I misclicked something as I was trying to pull this up, and it did a thing. I think I fixed it, but I don't know if I fixed it. But Lola, let's see. The StreamYard is difficult. I think I fixed it, but I'm not sure. Lola said, isn't a butt dial basically a booty call? Yes, different context. Yes, different context. And Miguelina, if you'll just make a note of the user handle, because I think I clicked on it wrong, because sometimes StreamYard jumps, and just double check that I didn't misclick. Thank you. Angelica said, this case feels like the never-ending story. It's much. It's much. Let's see. This was a great question from John, and I said I was going to hold it until we got to Q&A. The docuseries isn't under oath. How can they use it as evidence? The Commonwealth can introduce the party's own statements against her, even if they aren't statements under oath, and let the jury decide. And then Karen Reed's team either has to argue completeness, or they have to put Karen Reed on the stand to explain. So it puts the defense in a position to strategically choose what they want to do. But her statements are statements of a party opponent. So even though they are not under oath, they can come in because they are statements of a party opponent. And I think some of these statements are against interest. Again, the defense can't seek to admit them. The prosecution can, because they're from the other side. And we saw that happen a lot in Deptford here. Both sides were introducing statements of the other side, but couldn't introduce their own statements. Let's see. That's a good question, and I hope that makes sense. So I hope that makes sense. Let's see. My idea said for federal investigations are indictments only if there is specifically illegal behavior. Feds wouldn't have found Higgins destroying a SIM card, totally sus, but no indictment. He gets away with it because it wasn't technically illegal. You are allowed to destroy a SIM card. If the feds were looking into Higgins specifically, I imagine they were looking into his use of like FBI facilities, but it doesn't mean no indictment doesn't mean there's no criminal behavior. No indictment can mean a ton of things, including that it is either not the type of case the feds want to take, it is not the slam dunk that the feds want to take, there aren't broader implications, so they're not taking it. There's a lot of times that, just in my experience as a state level prosecutor, federal prosecutors, or really the investigators, would bring us cases and they're like, the U.S. Attorney's Office isn't taking this. And I would look at the case and be like, this is a solid case, but it didn't fit their criteria of filing. It didn't fit with if it's like a financial loss case, the size of the financial loss. So there's a ton of cases that can be prosecuted that the feds choose not to prosecute. They are fairly restrained in their filings, and they really do pick and choose their cases specifically. It's why their win record is so high. The feds aren't taking close cases at all. The feds are taking done and done. And so no indictment means that really there's a reason the feds didn't take it, but it doesn't mean there's no criminal activity. If there's no criminal activity, that's one reason. Thanks, Magdalena. Let's see. We're going to answer just a few more, and then I'm going to say we're going to have to jump just because. Thank you so much for the gifted memberships. Fluorescent, thank you for the gifted memberships. Casey Cat said Yannetti absolutely told Alessi, get in the car, Elizabeth. Anna says, what if Proctor flips? I mean, I don't think we'll see it happen, but I'm here for the fan theory. I mean, I think what we're going to see from the prosecutors is throwing Proctor under the bus. I think we might see it from the witnesses too. We're going to have to see if it's a different tone from last trial, but I think Proctor's getting thrown right under the bus this trial. I think everything's getting blamed on Proctor. Jamie Doe said, can former prosecutors serve on a jury? Yes, though it's unlikely in a criminal case. It would be more likely in a civil case. But yes, not all lawyers want lawyers on their jury. It depends on the case. What about if they're still living in the same district? No. If you are a prosecutor for the prosecutorial agency that is prosecuting the case, then no, it wouldn't be appropriate. Even if you are retired or have left, it wouldn't be appropriate. So would I can be on jury duty. When I was in LA, I got called for jury duty, but I wouldn't sit on a criminal case that was being prosecuted by the LADA's office. But I could sit on a criminal case from the LA City Attorney's office if anybody wanted a former prosecutor on a case. Sometimes they do, sometimes they don't. What I have found for me personally is that I can tend to be a bit more critical of the prosecution. Again, I think it's always a bit more critical. It's a bit easier to be critical of the job that you did. I also see the job specifically, and I think there are boundaries that should not be crossed. So can I be more critical of that? I can, but I don't know if that's how attorneys would suspect you might see a case. So it really just depends. But no, not if the same agency is prosecuting, but yes, otherwise. A lot of lawyers don't want lawyers on their cases. A lot of lawyers don't want lawyers on their cases. They don't want to look at another lawyer doing essentially what I do on the internet, just sitting there judging them. Also, it would be miserable for me to sit on a jury in a trial and not be able to run commentary out my mouth. Like, it would be so hard. I would be sitting on my hands. I would be fascinated, but I would be sitting on my hands because I'd want to be like, oh, that's interesting. Ooh, that's a great opening line. Ooh, what's that objection? Oh, I don't love. My face would show commentary nonstop, like nonstop. And that would be very hard for me. So I really appreciate being able to sit here and just do that out loud with all of you. Because I can't. I want to give commentary when I go to DCI. Ooh. That's an interesting choice for their wrapped rifles. Ooh, I like the way they blended, this song. And I want to give commentary on basically everything. I have thoughts. It is the running voice in my head all the time. Just all the time. I know this shocks you, especially those of you that follow me on Instagram during the Olympics. And we're just, as I was giving commentary on like Olympic water polo and stuff, you guys get to see it in different contexts. Let's see. J Pro said, I'm celebrating getting my driver's license. I'm more adult here now, but also didn't Jen McCabe admit on the stand that she texted John O'Keefe if he was coming over to Fairview? Yes. Why has no one pulled John O'Keefe text messages? They have John O'Keefe's phone, and they did introduce text to John from Jen, from Brian Albert, and so they were introducing the texts on the other side of the conversation. So they were introducing them that way. So Kim, I Love Labrador, said, girl, I can't wait for quick bits. We'll have a cut down of this, hopefully, and then if I summarized well, I think I did, and then I will have a new podcast for you guys on Monday, which is going to be, we're going to be zooming because it is Winter Guard finals this weekend and traveling, but I'm going to be prepping it while I am traveling for YouTube. I will keep you guys in the loop in the app on the YouTube event, and then in the Law Nerd Lounge, I'll be sharing some of the behind the scenes of that event. So we will see. I have been told I can record all the things I want to record, which is really difficult for me because I always get to an event. I'm like, oh, I'm going to record. But then I'm like, oh, but I want to talk. And then my phone goes away and I talk and I forget to record. So I'm going to get there a little early and get some behind the scenes before the event starts so that I can share some behind the scenes with you. Law Nerds, that's the plan. Stay in the loop in the Law Nerd app at lawnerdapp.com. It's free to you. We built it to keep you in the loop. I will be streaming next week, should be regular times. New podcast on Monday on the Quick Bits channel and on your favorite podcasting app. So do all the things and then, do the likey, subscribey things here, all of that. But Law Nerd app will keep you in the loop as we get into trial season, trying to figure out the Karen Reed case with kind of the new timing, the Corey Richins case, and then if Donna Adelson starts on time in June, the Donna Adelson case, and then getting into Koberger. We have some Koberger hearings coming up that I will be covering. We have a lot of motions in limine to cover in Koberger. I gave an overview of that in this week's The Emily Show. If you guys are not catching the Monday show regularly, it is part of the ongoing coverage here, and I am trying to keep you guys up to date quickly in that Monday coverage. But that coverage complements this coverage because it's keeping us moving forward in all the different cases, or at least that is my goal. I hope that you find it that way too. So, Law Nerds, it's time to go. Take care of yourselves. I am going to off and away. Have the best rest of your day, and I will see you streaming soon. Bye, everybody. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android so I can keep you in the loop because you never know when something's going to pop off. Thanks for being here and thanks for being a Law Nerd.